Good morning, good afternoon, all present and correct.
Yes, thank you.
Yes, my side, my lord.
All right, well, when you're ready then, please.
Thank you, my lord. I hope that you have received our speaking note, closing note, whatever one wants to call it. And what I was proposing to do today was to basically go through, in effect, take you through that. And I was going to address the following points in the order really that they're identified. So firstly, I wanted to make just some brief observations about the liability evidence. I won't dwell on that, but then get to the point that Your Honour is particularly interested in, I think, which is this question of obligations generally. What duties does this contract impose, and how does that relate with the duties of best faith, best endeavours and good faith? Then go through the breaches, pleaded and unpleaded, as best we can. We do object to the way the case is developed, and we don't abandon those objections, but I will do my best with the breaches that are now alleged, and then go on to look at whether those breaches could have given the claimant the right to terminate in 2018. It's obviously a big gap on any view between the breach and termination. Touch on limitation and anticipatory breach very briefly, and then come on to deal with quantum. Principles, the could and would, a few comments on the experts, deal with discounting, and then look at the inputs in the profit and loss. Your Honour is likely to be more interested in some bits than others, and I'm fully anticipating there will be questions. So, subject to those, I'll just take it in that way. Starting then with the evidence, Your Honour asked the question, what is the importance of the oral evidence? What does it actually, what difference does the oral evidence make? And the answer must be it's going to be relatively limited, albeit it is important for certain fairly discrete issues. We bear in mind the fact that we're dealing with witnesses' memory of things that happened up to 16 years ago. So the documents will be important, but there are some genuine factual disputes as opposed to disputes about how one characterises documents. And obviously, to some extent, the factual context, what was said behind the scenes, what was going on behind the scenes, gives some content to the documents as well. But in terms of hard, discrete, factual issues, what are there? I would say, firstly, there are some questions about what was going on behind the scenes for both of the parties. In terms of, firstly, for the claimant, we say that there are clear indications in correspondence in late December 2006, early 2007, that the claimant was going slow and was not cooperating with certain requests for financial information and so forth. We also say that there are some whole sides to this dispute that are being kept from you. So, for example, there are clear indications that CHL had some sort of deal with someone called Sheikh Mana after the 2008 Shareholders Agreement, and that is being withheld from you. There are clear indications, for example, that the CSI discussions that went on ground to a halt in late 2009, and that the claimant is not being frank with you about that. But on the defendant's side, we have this overarching allegation that the defendant's entire involvement in this project throughout was in effect a charade. That's the way the case was put in opening. That case obviously is based on inference. There's no direct evidence of any conspiracy of that sort. But we say if there had been, the witnesses that the defendants have produced would have known about it, and they would have been able to speak to it. So there's that part of it. Then there's some discrete points of detail about the way things developed in the 2006, 7 and onwards period. So there's the question about whether the Gensler design was approved. There's the question about whether the mix use was approved in April 2008 or agreed between Mr. Barazi and Mr. Suleiman Al-Majid, who of course you haven't heard from. And then there is an important question, which is whether or not the claimant could and would have proceeded with the JVA. That is different from whether it would have proceeded with the project, a project. It is whether it would have proceeded with the JVA, with all of the financing obligations that brought. That was a question. We say that that is now resolved because Mr. El Fadl conceded in evidence that it was not going to happen. that the claimant or CHL would put up the total project finance as liquid capital. So we say, the way he put it was, he said it was not foreseeable. But there is a factual question on that front. There's an argument about who bears the burden on that, effectively, and I'll come on to that. But there is a factual question there. And then there was a question of whether Mr. Visser renounced the joint venture agreement at various meetings that came after 2012. As I understand it, though, that cannot be advanced, even if it is, because Mr. Hosson conceded that in effect what you had were non-admissions, which he had construed. There was no express statement of the sort that would be required. But in terms of factual issues, that's about it, as far as we can see, on the witness evidence. You've heard a lot of noise from the claimant's side about documents and witnesses that are said to be missing. As to documents, the whole complaint is misconceived. There are rules about the circumstances in which the court may draw adverse inferences. The relevant rule we've identified in our closing is 2861, rule 28.61, and that draws the line between where the court can draw adverse inferences. And the rule is that adverse inferences may be drawn where a party fails to disclose documents in breach of a court order. So there is no scope, we say, to draw adverse inferences unless my learned friend is able to say, here is a court order, or here is a request you did not object to, and you failed to comply with it. I'll come back to adverse inferences on witnesses in a moment, but on the other side of the token, and I'll show you this in due course, we say it's clear that the claimant has failed to comply with an order. So one of the things, the reference is B43, and I'll take you to it in due course, but in order 1 that Your Honour made, one of the things that the claimant was required to produce was evidence of its ability and willingness to finance. So all documents relating to that. And we say it's now conceded by the claimant's witnesses that documents exist which fall within that category. You may recall on this front, in terms of documents, all you have seen is a single cheque for a large sum, yes, made out to a third party. And that is said to be sufficient evidence of the ability to find $200 to $400 million worth of financing. What we don't have are any bank statements, asset portfolios, land registration documents, evidence of shareholdings, none of that, all of which was accepted to exist. So we say there is a case for adverse inferences in that field, and I'll come back to that. The other feature, when it comes to documents, the other feature that we have identified in our closing is that we say it clearly emerges from some of the documents that there was a policy behind the scenes with the claimant to produce a paper trail. And that, we say, starts very early on. And paragraph 27 of our closing sets out some examples of that. You've got the references there. I can take you to the documents if you'd like, but given the references, given we've been through some of this in cross, I can just describe what's happening. Your Honour may recall the early 2007 email from Mr. Mukadem, and there was some correspondence there when Mr. Mukadem in late 2006 had said, we need to get these consultants on board, we need to get QSs on board. He then, at page 368, had given the impression that there were QSs on board, that there were consultants on board. Does Your Honour want to look at the document? Would that be helpful?
Yes.
Thank you. So the point is if we go to bundle F, page 366, we start at 368. Well, let's start at 367, in fact. You see Mr. Mukadem emailing. Yeah. So he's emailing his team saying, I need to have the QS, the consultant, identified and appointed. so I can finalise the project report. Now, this is all in the context of a request from the DIFC, which came in December 16th for various information, if you recall. And the response that goes back to the DIFC is, amongst other things, if you see on the next page, 368, second big paragraph, we are seriously working on it, and I assure you that we will present our document for you in quickest time possible. Some of the information requested needs to be confirmed with our consultants and our QS. So clearly giving the impression that there was a QS, that there were consultants. So this is getting some delay. And it goes on to say at the bottom, I'll keep you posted on the status, and I may give you partial submission if I will not be able to push our consultants and QS to reply to me in a timely manner. So you've got an email that says we need to appoint a QS, and then 2 days later, you've got an email giving the impression that there already is a QS. And then if you go on to the document at 373, you may recall this document.
Yes.
You've got that second paragraph. We gave them all that they want in a very broad way, and we took our time. As we all agreed, we will not commit to show and prove the financial aspects. And then there's all this stuff in there, and I won't go through it all, about complaints about delay, about the DIFC trying to push things forward, about and then at the bottom, at paragraph 4 of that, we need someone in Dubai so we can move quickly, take decisions quickly. And then the other example comes much later in the piece. I won't take you to the letter to Her Excellency, but there's the email from Mr. Ali, again within the team, and this time we have to go to bundle F3, I think it is. Yes, bundle F3, please. Is it? No, F4, sorry. F4, my apologies. And it's tab 234. And you'll see, you may recall this email from Mr. Ali to the team. While we thought it was okay to have that second line to enter into an agreement with Sheikh Mana, as this agreement will not be shared with the DIFC, we believe that an authorization letter given to Sheikh Mana should be granted by Hexagon and CHL so as not to give DIFC any further evidence that Hexagon had accepted the termination of the original agreement. And if we skip a sentence, furthermore, we feel it is very important to reference the last letter we sent to the DIFC on this issue. So we make sure that if the negotiations fail, this will be the basis for any claim. Of course, we can explain to Sheikh Mana that ultimately what we are interested in is a new JV along the lines outlined in the CHL agreement with him, but that for the record, we need to maintain our original position in case his mediation fails. So you've got a clear indication of this policy to present on the one hand, a paper trail, which does not reflect the reality of what is going on behind the scenes for the claimants. And amongst those points, and I won't take you to this, but you will recall, Your Honour, the 2015 term sheet, for example, and the way that was presented to the DIFC. It was said that it was consistent with the terms of the joint venture agreement, which is a remarkable suggestion when one actually goes through and understands it, and must have been known that it's clearly got nothing to do with the terms of the joint venture agreement. So there are other points that we raise. I won't go through them all, but what I say is that when one looks at documents, and you'll see a number of occasions in the documents which are relied on, where it said, oh, there was an agreement here and there was an agreement there. When one comes to reviewing the accuracy of that sort of thing, I suggest that Your Honour ought to bear in mind this clear policy that we can see. All right. And on witnesses, I did want to say just a few things about witnesses. You will have formed your own view of the witnesses, and so I won't labour it. We heard your immediate impressions of Mr. Hosson. Frankly, we would suggest none of the claimant's other witnesses were at all satisfactory. And we've set out a bit of detail about why we say that. And you'll find that starting at paragraph 14 of our note onwards. And I don't want to take you through everything in detail, but that is there for you if it's of assistance. I might just give you some of the headlines, if that's all right. It's saying something, but of the four, we would suggest that Dr. Adil was probably the best, in the sense that he was at least trying to be honest about his evidence, but we say he was very clearly and admittedly acting as an advocate. He described his points as arguments on more than one occasion, and it was very difficult, we say, to tell what was his actual recollection, what he recalled being told by someone or reading somewhere, or what he was just reconstructing in retrospect. Mr. Al-Majid, we say, was clearly reconstructing history on a number of occasions. Again, it was impossible to tell what he really genuinely remembered and what he was reconstructing. So he said he remembered being told things, but couldn't remember when the meeting was, who it was with, what was said, and so forth. He said a number of things that were directly inconsistent with the documents. So, for example, he denied flatly that from his side, he and his brother were looking to amend the joint venture agreement from the very beginning. So I showed him a document which you'll find in bundle F1 at page 23 with a handwritten note on it saying Suleiman Al-Majid has confirmed that he will keep on working on a better agreement with the DIFC. That was dated 12 December 2005. And confronted with that...
Whose note do you say that was?
Well, it's a content... Well, it's we don't know. It seems to be signed by Mr. Papadopoulos.
I'm sorry?
It seems to be signed by Mr. Faiz Papadopoulos, but it's not clear.
Two signatures on the document.
Yes.
And if you look at the handwriting, one can take a stab at which one of them might have written the note, but it's guesswork, isn't it?
It is, but you've got Mr. Mukadem signing it, who was the representative from the Al-Majid side. So confirming that that is what the plan was behind the scenes. So yes, one might say perhaps there was a great mismatch of expectations and understandings behind the scenes, but where would Mr. Mukadem, who isn't before you, where would he have got the impression that the plan was to try to get a new transaction right from the beginning? And so can it be right? Can Mr. Al-Majid's evidence be right that that was not the plan in light of those documents? It just seems to be very unlikely. He was showing the document from 2007, which I've just taken you to, and essentially his evidence was to deny that their side was behind schedule, that they'd hardly made any progress. He then started to question Mr. Mukadem and whether or not he perhaps was just being inaccurate in all the way through all of this. His written evidence in relation to CSI, you'll recall, was that CSI could not be brought in as a funder because of action taken by the defendants, and that included renunciation in 2012. You may recall that, and the reference there is in his witness statement of paragraph 84. But the evidence shows from the claimant's own side that CSI was terminated because they did not come up with a finance structure. You'll remember that from their presentation. That's at page 1775. I showed Mr. Al-Majid the business plan for TPM International in September 2009, and his response was to question it constantly. He questioned whether it applied to the DIFC. We could see from the next slide that it did. And eventually he had to question its author, who as I understood it, was the CEO. So we say that he was repeatedly denying documents and had demonstrably given evidence that couldn't be true. In relation to Mr. El Fadil, we do say, I'm afraid, that he was the worst of the lot. He said a number of things which were plainly untruthful about who he was acting for. He denied that the parties thought that the 2008 Shareholders Agreement was effective. That's something that Mr. Al-Majid actually accepted. You asked the question of my learned friend yesterday. What was the position? In fact, Mr. Al-Majid, as you said, had said in his evidence repeatedly that it was a draft document, and Mr. Al-Fadil maintained that approach. He said he thought it was a void document all the way through his evidence. He said he thought it's null and void, and that's even though, even by as late as December 2009, we see in an email that's referred to and relied on by the claimant in its pleaded case, he's demanding compliance with the terms of the Shareholders Agreement, and yet he's telling you, the court, that he didn't think, that he thought it was null and void. That was the phrase that he used.
Did Mr. Al-Majid accept in his oral evidence?
He did.
He did.
He did. I'll take you to that. I do have the note, but I'm afraid it's slightly out of order. But I will take you to that, or someone will help me find it. I think I deal with it slightly later on, I'm afraid, so I don't have it in front of me. But
I don't.
Yeah, no, he accepted. So in his written evidence, he said yes, it's draft, and then in oral evidence, he did accept that everybody thought that it was binding. But as I say, I mean, really the critical bit of Mr. Al-Fadil's evidence was his acceptance that it was not foreseeable that by the end of 2009 that the claimant would inject the total project capital as liquid finance. The defendant's witnesses were subjected to some pretty remarkable attacks. There was this attempt to smear Mr. Barazi. Now, that attempt was hidden behind a very thin veneer. My learned friend said that he wasn't raising any allegations. Well, if he wasn't raising any allegations, one has to ask why the points were raised at all. Because if it's not being alleged that Mr. Barazi did anything wrong, then how could that possibly have any impact on his credibility? So it was, I'm afraid, a totally inappropriate abuse of the privilege that attaches to making those sorts of statements in court. And it goes nowhere. The only evidence you have is from him, and it's accurate that there was a dispute between him and the DIFC. Where does that, and which he was successful in, and none of the allegations were made out. How does that actually affect anything? It shows he's got no axe to grind, in this proceedings. He's a totally independent witness. He's fallen out with the DIFC. He doesn't work for them anymore, and yet he's happy to come and give evidence about it. He was entirely upfront about what he could and couldn't remember. He made very clear when he could remember things and when he couldn't. He never pretended otherwise. I would suggest there's no reason really to doubt his evidence. On Ms. Calaresi.
Before you go to Ms. Calaresi, was it ever put to Mr. Barazi that he was part of a deliberate conspiracy to go slow or not to put the AJV into effect?
No, I don't think it was. I don't think it was ever put that high. It was said as to specific and discrete allegations and complaints. It was said, well, that's not exactly good faith. Well, that's not exactly best endeavours. But there was never a stepping back to say, well, behind the scenes, there must have been an agreement, some sort of conspiracy to, in effect, engage in sham negotiations. And as we say in our closing, it's quite hard to distinguish that sort of allegation from an allegation of conspiracy to defraud, conspiracy to deceive, at least. A sham negotiation is a dishonest negotiation, in the same way that a sham agreement is a dishonest agreement. It's intended to deceive. And I make the point, I think, in closing, if I don't, then I make it now. It is different from what was described as filibustering. The difference is that filibustering, everybody can see what is happening. You are taking command of the floor in the House and wasting time to make sure nobody else can use that time. It is clear what you are doing. You're probably reading from a book, which is how it's usually done. Whereas what is actually being alleged is a form of deception. So pretending to negotiate when you're not negotiating. That was never put. And as I say, I mean, if there had been something like that going on, first there would be documents clearly, and they would have to be suppressed now. And secondly, Mr. Barazzi would know about it. So I was going to just very briefly touch on Ms. Calaresi and Mr. Visser, but not in great detail. Ms. Calaresi was, I would suggest, quite impressive. She told you when she couldn't remember details, and there was quite a lot of that. But she gave, as Your Honour observed, a perfectly reasonable explanation for what was going on and why the decision was made in 2012 that the JVA was not binding. And in retrospect, and we'll come on to this, while the contract might have been binding technically, we would say that any obligations had been exhausted by that point, so it had no content. So she was probably right. Mr. Visser, we say, was also a compelling witness. The fact that he was subjected to extraordinarily aggressive cross-examination doesn't affect that. And on the real factual dispute in that period, he was never cross-examined. It was not suggested to him on these discrete issues about whether he'd renounced or not. It was never suggested to him that he did. So all of that actual factual dispute has really rather gone. And then it's said that we're missing a witness, Mr. Al-Najjar. That's the first time it's been raised, as in closing, of course. Just briefly, I mean, your Lordship will know what the law is on adverse inferences, but just the points that we make very briefly on adverse inferences is said to be that you can make some sort of adverse inference from the absence of Mr. Al-Najjar. But Your Honour is looking for something. Can I help with it?
No, you carry on.
Sure. But adverse inferences, first, there needs to be a case to answer. Second, it's very often sought and very rarely ordered. Its use is to be deprecated. Third, if there is a reason, good or bad, then that is usually sufficient to nullify. The reason we give for Mr. Al-Najjar, or the reasons we give for Mr. Al-Najjar not being here, are: one, Your Honour's orders on disclosure indicated that actually the pre-2012 period was not of huge relevance for limitation reasons. So we were guided by that to some extent. Two, we do in any event have a witness who can speak to the questions. Was there some overarching blocking strategy throughout that period? That was Mr. Barazzi. Three, the courts often say that parties shouldn't double up on witnesses for the efficiency. Four, one questions, I can put it like this, one questions what the point would be of producing for you a witness whose only position would be, I don't really remember very much about it. And then the final point is that these detailed allegations which have finally emerged don't appear on the pleadings. So you don't see any actual case on GFA, BUA, mixed use, affection plan. All of that doesn't appear on the pleadings. So how are we to know that we need a witness to deal with it? Given the limitation issues that we have, we say it's hard to see what could turn on Mr. Al-Najjar's evidence. And Mr. Al-Najjar was not involved between July 2009 and 2014, even on the claimant's own chronology. You see that in their note at paragraphs, pages 23 to 24. So, you know, and then when one actually asks, all right, what is the proposition? What is the finding of fact that your Lordship is asked to find, and in respect of which your Lordship is asked to draw an adverse inference? Is very difficult to understand. The oral submissions I've recorded on that were yesterday, page 36, line 7. The issue that was identified was, did the world change, and did that have an impact upon where the parties had got to commercially? That was the issue that was identified as being really crucial, and to which it was said you couldn't find an answer without Mr. Al-Najjar. It's not obvious where that goes. The world clearly did change, and where the parties got to commercially is a matter of communication between them. The other way it was put, page 36, line 13, my learned friend said, It's simply not open to the DIFC to advance a case based on the DIFC or commercial grounds inconsistent with what was reached in the SHA without calling Mr. Al-Najjar. Now, what was or wasn't consistent with the joint venture agreement, what did or didn't was communicated between the parties, it is a matter of construction of the documents before you. And as I say, Mr. Al-Najjar was not there between 2009 and 2014, so he wasn't there for the 2010-2012 period. And anyway, there's no case other than on the two memoranda for that period, and we'll come on to that. So, my lord, I didn't want to dwell too much on the witnesses. Your lordship will have had an opportunity to see what was said, and will be able to read what else we say in more detail about the witnesses. But I wasn't going to dwell on that at this stage. What I wanted to do was really get on to the central issues and start in particular, this is at page 12 of my note, with what are the duties on the parties? What is the obligation? How does it fit with the obligation for best endeavours and good faith? And your Honour's sort of overarching question, what is the scope for variation or agreement of something different? What are the obligations insofar as they impact on that? And how can Your Honour adjudicate if there are commercial or negotiations to be undertaken? So I'm going to deal with all of that. But just as an observation, we've now got another 123 pages of submissions from my learned friend. And what is a little extraordinary is there is very little analysis at all of what the claimant says the defendants were obliged to do by reference to the actual terms of the agreement, save in the broadest of terms. My learned friend hasn't actually, he hasn't actually answered the question that your lordship posed, which was what is within and what is without the obligation to negotiate that's relied on? What actually falls within that? And when you look at the actual terms, we say, the whole thing falls apart. So our closing focuses really on this obligation to execute a shareholders agreement. That's where you asked us to focus our submissions. Obviously, we have more to say about sale and purchase agreements, but we see the shareholders agreement has to be the obligation to execute a shareholders agreement has to be the primary complaint. And I think your lordship has on board that the parties very quickly started talking about departures from the strict terms of the joint venture agreement. And so there are multiple comments from people like Mr. Hosson in his evidence for the immediate judgment application, which was that it was impossible to make progress on the deal on the strict terms of the joint venture agreement. Now that sort of observation prompted your lordship's question, and looking at the terms of the 2010 memorandum prompted this same question. How close is close enough? So how close does the draft have to be? How does the duty of good faith and best endeavours affect what needed to be agreed? And as I've said throughout, when your lordship looks at this, it's important to keep two aspects of the transaction discrete and distinct. They are the project computations, things like GFA, built up area, project mix, that sort of thing. The actual, if I can put it like this, the project, the parameters of the project. And then on the other hand, the commercial terms, things like financing. And there are two reasons why you have to keep them distinct. The first is that the terms which deal with each of those aspects are different. So we're looking at different text. And the obligations in clause 3.2 of best endeavours apply only to specific parts of the joint venture agreement. And the second, though, is a more commercial point, which is that the commercial terms are different in nature. There is a core commercial transaction which has been struck between these two parties about how they're going to share the burden and the benefit of producing this project. And as you know, we say the real sticking point between the parties was financing, not so much the computations, where agreements had been struck along the way. But on financing, the issue is not just about the shareholding split. And that is clearly one commercial issue between the parties. But actually the manner of financing was really more central. And in particular, this question of whether the joint venture company could borrow, or whether the claimant had to invest the finance as an equity contribution in exchange for shares. So if we've got to keep these two in my submission quite separate. And when we come to this question of understanding what the obligations are on the parties, I say my own friend faces really three immediate central problems, which I say they have not even begun to address. And if I am right on any of them, the claim, I say, has to fail. And just to summarize them first, and then I'll walk you through them. The first point is that on the terms of the JVA themselves, there is no obligation to negotiate any kind of variation of the project or the financing, or a relevant part of the financing. I'll show you there's one discrete part of the financing which could be subject to negotiation, but it's not the ones that we are concerned about. So that's the first point. There is no obligation, no relevant obligation to negotiate that could have been breached. The second is that even if there were, it would be confined by the terms of the joint venture agreement. There could be no obligation to vary the terms of the joint venture agreement. Your Honour may recall, you specifically asked my learned friend whether an obligation to negotiate in good faith could require a party to vary the agreement. My learned friend said yes. As a matter of law, that's wrong, and I will show you that. But even if it could work in principle, which it can't, in this case it can't. Why? Because you would need nexus to agree to a variation of the joint venture agreement. And then the third point is that if there was some sort of obligation to negotiate on these sorts of commercial terms, it would be unenforceable. And the problem here is that for the claimant is that the more scope there is for negotiation, the less prospect there can be for that sort of clause to be enforceable. And the less scope there is for negotiation, the less my learned friend is able to say that there's some sort of relevant duty which has been breached. And once we get to the point that he is saying, once we get to that point, he's saying we have to negotiate and agree new commercial terms about financing, then we say there's no yardstick that your lordship could find to judge that sort of exercise. So those are the three overarching points that we raise, and it starts at paragraph 44 of my notes. And so much of the debate has started really from the premise that there is an obligation to negotiate some sort of adjustment, if I can put it in those sorts of terms. So Your Honour was particularly interested in the project computations, so I was going to deal with that first and then come on to the financing obligations themselves. So to do this, we're going to need to look at the joint venture agreement itself. If I can ask you to pick it up, please. It's at bundle J, tab 1. On page 5. So we'll see. Sorry, page 6, sorry. 3.1.3. 2, sorry. No, it is 3. 3.1.3. The parties and the investor shall execute the shareholders agreement in a form prepared by Nexus in accordance with the provisions of Schedule D and approved by the master developer and the investor. And then we have that amended. Sorry, the amendment then introduces the best endeavours clause, which is at page 28 of the bundle in the next tab, 3.2. the parties shall use their best endeavours in good faith to complete the steps and procedures set out in clause 3.1 as soon as is reasonably practicable after the date of this amendment agreement. So what does the best endeavours clause obligation attach to? It attaches to the discrete obligations in 3.1, 3.1.3 being the relevant one. It's best endeavours to execute the shareholders agreement as prepared by Nexus in accordance with Schedule D. So it's a shareholders agreement. Just dealing with project computations at the moment, there's no particular reason why computations should be incorporated into the shareholders agreement. So there's no obvious way to say the best endeavours agreement requires any kind of negotiation of project computations at all, because it's dealing with shareholders agreement. Where does the fact, where does it come from that the JVA contemplates changes to the computations? The only place that comes from is clause 2.5.1 of, we find that in J28. Sorry. My notes got wrong. Apologies, it comes from Schedule E, doesn't it?
Well, it's 2.1 you want, isn't it?
Sorry, that might be wrong.
Of the amendment.
Yes, that's right. So the amendment is to Schedule D, Part 2. But where? So yes, sorry. So it's paragraph 2 of Schedule D is where we're supposed to be going. Yeah. My notes have gone wrong. So if we start on page 15, this is the place where the fact that it's the JVA contemplates amendment to the project computations comes from, because we see it in the bit that comes after the 1585 split. So it says, whilst the parties and the investor may mutually agree to a variation to any one or more elements of the project computations, thereby necessitating a consequential adjustment to the above shareholding percentages, and so on. So there are a series of problems with this from my learned friend, because what he needs to do is say, well, the obligation in 3.2 somehow attaches itself to the ability of the parties to agree amendments to the project computations. And the only way he can get there is through this particular provision. And so we set out some of the problems with that in our skeleton. But one of the problems is that, if you recall in opening, Mr. Williams's case was that this whole provision had been deleted.
Yes, well, what's your position on that? I don't know why I'm getting an echo at present. Are you getting an echo from me?
I'm not, my lord.
Oh, right. Perhaps it's just here. What's your case as to what happens to that paragraph of Schedule D, paragraph 2, when clause 2.1.1 of the amendment is agreed?
We say that 2.1.1 replaces the bit at the top, but not the bit at the bottom.
Right. Which leaves one, you say, with the potential for the parties to reach agreement, but no obligation.
Correct. But I'm just making the point that the case on quantum and the case on liability from the claimant are diametrically inconsistent with one another. So it must either be right that that is deleted or it is not. If it's deleted, you are left with nothing in the JVA that provides for adjustment of the project computations. If it's not deleted, well, then clearly one has to allow for adjustment of the shareholding at the end of the case in quantum, and can't have it both ways. But you've got Mr. Williams telling you it's deleted, and my own friend Mr. Sprange relying on it in his closing submissions. So it's an incoherent case. So that's just the first point. The second point is that, well, we say it remains, and let's assume it does. But clause to this particular provision, it is not the subject of clause 3.2. So the 3.2 obligation to use best endeavours to negotiate and agree amendments to the project, to the shareholders agreement, does not mean that there is an obligation to use best endeavours to negotiate amendments to the project computations. The result of that clause is that if different project computations are agreed, then at the end of the day, that could affect the party's shareholdings. So it could affect what is in the shareholders agreement. But that doesn't mean there's an obligation to agree different project computations. There's no reason why the mechanism for adjustment wouldn't just be carried over into the shareholders agreement. There's no reason why there would need to be any agreement as to project computations that would be in or even reflected in the shareholders agreement. So, my lord, that's why we say, really, they don't really get off the ground. You don't really get into questions of good faith. What does that mean? What's good faith in negotiation of project computations? It just doesn't arise because there isn't an obligation that attaches. And my learned friend asserted that some aspects of this agreement were arguably varied by the shareholders agreement. That was the way he put it in submissions. And in relation to the financing obligations, he argued that they were in no way critical to the outcome of this case. As to the shareholders agreement submissions, we don't understand those. Either the shareholders agreement in 2008 was binding or it wasn't. We thought that everyone had agreed that it was not. But if it was binding, then the DIFC should be entitled to 35%, not just the 20% that's allowed for. But it now seems clear they're not saying that the joint venture agreement was amended in any way. So you can't derive any particular obligations about project computations from the discussions that led to and ended up incorporated into the 2008 shareholders agreement. So that's project computations. It just doesn't get going. As to financing, that is dealt with in Schedule D, paragraph 6. And what we've done is just break that up into, it really falls into 5 parts. You'll find it on page J16. And there is one limited area in there for discussion, but it is not one that is relevant. It is about the timing of the provision of funding by Nexus, and that is it. So if we just break down paragraph 6 really into the 5 parts, if you have that, you'll see we do this in our note at paragraph 47. So you've got number 1 is the master developer is not obliged to provide anything but the land. So there's no negotiation even contemplated in respect of that. Number 2, there is a potential dispute as to what happens to off-plan sales revenue. You may recall that I raised this in opening. So that there will be off-plan sales revenue. It's then applied to reduce the total project capital to be invested. And then there's got to be a question about whether that is factored into the shareholding or not. In other words, are we really showing what net cash is invested as against the value of the land, or is it just random as to the claimant takes all the benefit of off-plan sales? We say there's a commercial answer and a construction answer, but that's not something for negotiation. It's just a matter of construction.
Yes.
The third part.
It seemed to me the construction was relatively clear in the context of the clause as a whole, and made clear by the words only to such extent from time to time.
Yes.
Which suggests that it's a cash flow point.
Yes.
And at the end of the day, it's got to be taken into account. Otherwise, it has the effect of changing the basic position that one party provides the land and the other party provides all the capital.
Well, quite. And one can think forward all the reasons why the parties would not agree it in a different way, because it would just distort, for example, the sort of project that they might want to do, because then you've got if one thinks about the difference, for example, between the so-called approved project and the highest and best use project, one's going to generate lots of off-plan sales and one's not. So you've got two parties then pulling in different directions for their own commercial reasons. The next paragraph is the one where there might be room for agreement and negotiation, but not relevantly. So the shareholders' agreement shall more fully enunciate the arrangements for the investment of the liquid finance by the investor, so as to ensure the timely availability of funds to undertake the construction and so forth. Now, the importance there is that, so that is the only bit that's left for discussion. But the importance there is there's going to be an objective standard by which you can determine what ought to be agreed there. So if the parties don't reach agreement, you would be in a position as the judge to say you've taken an unreasonable position. The objective standard is what is going to be needed for cash flow purposes. Yeah. And so once you agree the works, you can predict when the money is required. And then there's nothing else. So the next bit is no part shall be borrowed, whether from the investor or otherwise, and so forth. So, and that is not subject to any kind of discussion. That's just a principle to be carried over into the shareholders' agreement. So when we actually look at the obligation to which the duty of good faith and best endeavours attaches, we say it's very limited indeed.
What does the last sentence cover?
It doesn't. Well,
what additional capital requirements can there be beyond those that have already been referred to as total project capital costs and working capital and project capital?
Yes, I mean, once one's accounted for working capital, it's very difficult to see, and so it looks like belt and braces.
Right.
That's what it looks like. It's very difficult to know what could otherwise fall. But anyway, it doesn't affect the point that I'm making, because that is to be resolved by the shareholders. So there's nothing in there to be agreed in the shareholders' agreement, and it certainly doesn't cover the sorts of things that we're talking about and that are fixed. So actually, when one looks at it and understands it, there's no duty to negotiate these sorts of issues, financing or project computations, and all that is required is that the parties use best endeavours to execute a document prepared by Nexus in accordance with Schedule D.
Yes, well, that raises a point I wanted to ask you about. In practice, these two parties effectively decided that Nexus was to be taken out of the equation by being bought out in one way or another by the DIFC. It's obviously open to two parties to a tripartite agreement to enter into a contract between themselves that has the effect of varying the tripart agreement as between them. Doesn't impact on Nexus, of course, but there isn't any reason why they shouldn't do that, is there?
No, if they enter into a binding agreement to do so, then no, there's no reason why they can't do that. It may put them in breach of contract as regards Nexus, and when we come on to the shareholders' agreement as regards Hexagon as well. But no, there's no reason they can't do that. But the question becomes...
The question then arises, what does that do to a provision of the kind that we're looking at here, which says that Nexus is to provide the draft?
Well, we say that is important, because the fact that parties can agree a solution to a problem that's presented by a contract doesn't actually affect the construction of the contract and whether or not they're bound to do anything in particular by the terms of this contract. So what we say is this: actually, it's been disregarded to a large degree, but the role of Nexus is very important, because, and I'll come on to dealing with good faith, best endeavours, but the critical factor in making those sorts of provisions enforceable is twofold. And we'll see this in the judgments as we get there. One is certainty of object, which is having something on the table to look at and respond to. And the other is an objective yardstick by which to judge the response. And Nexus was to provide both of those things. You get an independent determination of what is an appropriate JVA, and it needs to be approved by the parties, but then one would have implied terms of Braganza style, not to be approval not to be withheld unreasonably. So if you take away nexus, then an obligation, we say, to negotiate a shareholders agreement which is consistent with the JVA, even that loses content. Even that can't be done. But that at least informs how broad the duty could be.
If one goes back to the genesis of this project, which is shrouded in mystery to some extent, my understanding, and I may not have this right, is that Mr. Radbay was both Nexus and, at least in part, Hexagon. Is that right?
Is that right? I'm not sure. He was certainly in part Nexus.
When did Sheikh Juma come into? The question that I have is whether Sheikh Juma was in Nexus at the outset or came in slightly later. And I have a recollection, I think from the evidence of Mr. Abdullah, that they bought their shares from him, so to speak, but he wasn't necessarily the original.
Oh, so Sheikh Juma was Hexagon, I think you said Nexus.
Yes, but what I'm asking you about, and I say I may not have this right because the evidence wasn't clear, that Radpay was in fact Nexus also at the outset, and Sheikh Juma only came into Hexagon at a later stage. In other words, Nexus was very close to Hexagon from the outset.
You may be right. I don't know. I'm not sure, and I'll have to check that. I'll check it over the lunch break, and if I can shed some light on it, I will. My understanding was that Mr. Radpay was connected with Nexus, certainly, and he was also connected with the DIFC, and that was the source of the conflict of interest, but that had been disclosed. Albeit there was a question. I don't know about his connection with Hexagon. I had not picked up that he was also connected with Hexagon, but I don't think there is evidence to that effect, but I will check.
In the bundles, there is somewhere a document that shows what appeared on the share register for Hexagon. Where it is, I haven't a clue.
We shall dig it out.
Fairly confident that it was exhibited by someone, and I rather thought it was probably Mr. Abdullah in one or other of his witness statements. But I may have got that round my ear. But if someone could have a look, that would be helpful.
We will. We'll dig that out.
The only relevance to the point is this: that if Nexus is much closer to Hexagon than you appear to be suggesting, there's a slight oddity about Nexus being in a position to produce the draft as a quote third party, where there's a measure of objectivity about what appears on the table.
Would that still not, though, simply be a feature of what came next rather than what the terms mean? Because if one looks at the agreement, at J5, for example, the condition precedent is that Nexus will identify an investor, whoever that may be. So on the terms as agreed, the mechanism was simply that it could be anyone, and therefore that's why I say isn't any connection between Mr. Radpay and Hexagon really a feature of what came next, rather than a method of construing the document, or useful for construing the document.
All right.
In any event, that is sort of point number 5 down my list of reasons why we say we're not in breach. But we do say primary case, Nexus had to provide the document. But even if someone could stand in their shoes, we still need to be provided with a document. And then subsequently, we say there's no obligation to negotiate on any of these 2 points. My learned friend's submissions on this, we say, were very high level and inaccurate, frankly. I've got a note of what he said yesterday, page 13, line 12. He said, we say this means that the parties accepted that in using best endeavours and good faith to pursue the project as defined, that things would change. Well, there was no obligation to use best endeavours to pursue the project, whatever that means. There was an obligation to use best endeavours as soon as reasonably practicable to execute a shareholders agreement. So we say that is a fatal point for the claim. It stops there. Next point. All right, assume that there is some sort of obligation to consider or negotiate changes of some sort. The terms of the joint venture agreement are binding on the parties, and there can be no obligation to agree a variation from that agreement. So the things that are fixed are fixed. So if it says it's for Hexagon to put in all the money, but you're obliged to negotiate a shareholders agreement which will deal with financing, you're still stuck with the fact that Hexagon puts in all the money. So this is the point that my learned friend said, well, there could be that sort of agreement, and the answer is that it's wrong. And you'll see it there in our submissions, starting at page 16, paragraph 55, and it's simply that paragraph 56, that sort of duty can't require a party to give up a financial advantage. There's a New South Wales case which has been enshrined into English law as well by the Mr. Justice Voss, as he was in those days. So we just say you're stuck with the terms of the agreement, and then you've got the problem of nexus as well. So how do we actually go about agreeing a variation to these financial terms without having nexus being party to it? How do we vary the AJVA? So there's a problem on the law and there's a problem on the facts, but either way you can't, you're stuck with what's in Schedule D. So that's point 3, and that's before we get on to the very interesting points about what is the enforceability of obligations to negotiate in good faith. And I just wanted to take you through this because there's been a bit of discussion of this, obviously, over the course of the hearing. And it starts at paragraph 62, where I know there is now a Court of Appeal authority about certainty of terms in the DIFC. Slightly different context, that was a lease, but nevertheless, it incorporates the underlying principles. And then paragraph 63 is the classic statement from Walford and Miles, which you know about. So the concept of a duty to carry on negotiations in good faith is inherently repugnant to the adversarial position of the parties when involved in negotiations. Then you have Petromech, and some reliance is placed on that. Now, Petromech is to some extent a departure from the orthodoxy, but actually it remains within the confines. It doesn't really change the law. What Lord Justice Longmore did was he identified the underlying problems with agreements to negotiate, and he said they didn't apply in that case. And so you see at 65 the 3 major problems that he identified. The obligation is an agreement to agree and too uncertain. It's difficult, if not impossible, to say whether, if negotiations are brought to an end, the termination is brought about in good or bad faith. And since it can never be known whether good faith negotiations would have produced an agreement at all, or what the terms of any agreement would have been, if it would have been reached, it is impossible to assess any loss caused by breach of the obligation. And decided that in large part because what had to be negotiated in that case was comparatively easy to ascertain, that it was enforceable, therefore that particular clause was enforceable. It's fair to say that those 3 reasons that he announces in what I've recorded in paragraph 65 is not the start and finish of the complaints about agreements to agree, and some more of them are. We'll see them coming through in the subsequent cases, and you'll see in particular at paragraph 69 decision of Mr. Justice Tier in the Charles Shaker case, and you'll see there that what he identified as being the central reason, we've underlined it, for the unenforceability is because there are no objective criteria by which the court can decide whether a party has acted unreasonably. and that also because it's inherently inconsistent with the position of the negotiating party. So those are the two central problems. That's why I say perhaps Lord Justice Longmore had missed out the second one, but in any event, it exists. And then he did not follow or he distinguished the case of Petromech, as we see from paragraph 70. Why? Because in that case, the costs could be assessed in the absence of agreement. There were objective criteria. And so an agreement, but then he goes on to say an agreement to negotiate the terms of 4 further agreements and secure written confirmation from a financier contains no objective criteria by which such agreements or written confirmation could be produced for the parties by the court in the absence of agreement. This was looked at again by Lord Justice Gloucester. I won't trouble you with the IBM case, but paragraph 72, we've got Morris. I can trouble you with the IBM case if you'd like me to, but you'll see just a few comments from Lady Justice Gloucester in Morris. Firstly, the fact that the relevant provision requires the parties reasonably agree doesn't turn it in an unenforceable provision into an enforceable one. 2, parties are not required to disregard their own commercial interests, and that again makes it very difficult to police commercial negotiations between parties. 3, if a party judges that its own commercial interests militate against agreeing the relevant matter, it's entitled to take that stance, and there is, for this reason as well, no enforceable legal obligation to the contrary. And then 5, examples of unenforceable agreements included an agreement to use reasonable endeavours to agree the terms of a joint venture regarding 2 airports, having regard to certain agreed principles. So my learned friend relied on the case of Astor Management yesterday, and you'll recall some reference to that. But he disregarded what is the key distinction in that case, which is between negotiations with your counterparty on the one hand and negotiations with a third party on the other. And so Astor Management was about someone being obliged to use their best endeavours to agree something with a third party to go and get financing. And to look at this, you have to start with the prior case of Danny Lyons. So you'll see there Mrs. Geraldine Andrews, as she was in the Danny Lyons case. I've got the passage there at paragraph 74. So you see, she says that, and this is the point I was making earlier, those 2 essential requirements of certainty of objects and a yardstick by which to measure the endeavours are applicable across the board, whatever the object may be. They will not be satisfied in a case in which the object is a future agreement with the other contracting party. Because even if the first requirement is satisfied, e.g. there is a draft contract on the table, and the second will not be. They may be satisfied if the object is a future agreement with a third party, but such cases are likely to be exceptional because of the difficulty of satisfying both requirements. The essential terms of the prospective agreement with the third party are identified in advance. There may be both the requisite certainty of object and sufficient criteria by which to judge the endeavours. If those terms are left open for negotiation, satisfying the second requirement is just as problematic as it would be in a case where the prospective agreement is with the other contracting party for precisely the same reasons. So in relation to, in the Astor Management case, it was that bit that Mr. Justice Leggett, as he was disagreeing with, the bit about negotiations with third parties. And so that's why he says at 64, I cannot agree that the requirements of certainty of object and sufficient objective and criteria are difficult to satisfy and will not usually be satisfied where the object of an undertaking to use reasonable endeavours is an agreement with a third party. And one can see, at first blush, one thinks, well, what's the difference? You're still talking about agreements to negotiate. But actually, if you think about it, there is a clear distinction, which is about allocation of risk. So if I say, I agree, I'm going to go off and get financing, I take on the risk of that negotiation. And so if the provider of the financing plays hardball in the negotiations, then that's my problem. I just have to deal with it. That's the risk I've assumed. But if I've agreed with you that we will enter into reasonable endeavours to agree financing, there's no yardstick. There's no way to determine where the line is to be drawn. It's a logical problem. It's the adversarial nature of the negotiations. And in order for the court to decide that, it has to then start making commercial decisions, which is absolutely not its role. That's not what we lawyers do. We assess the law. We don't deal with commerce, and that's the passage that we see in the Phillips Petroleum case, and we recite it on page 21. It's quite helpful, actually, I think, just to look at that.
There's a difference, isn't there, between two parties to the agreement and going to a third party and exercising with reasonable endeavours or best endeavours to reach an agreement with third party. Because where the two parties are concerned, they are in an adversarial position against one another. And therefore it's impossible where both sides have to, as both sides' responsibility has to be taken into account, to have any yardstick at all by which to measure what they ought to be doing. Whereas in relation to a third party, looking at whether one party is exercising reasonable endeavours to reach agreement with a financer, that's a different question altogether. There's no adversarial aspect as between the parties to the litigation.
Precisely.
So there's a real difference in looking at an appropriate yardstick. Yeah,
and one's possible and one's not.
Yeah.
So cases like Asta Management don't help the claimant in this case. Those sorts of agreements are unenforceable. And so even if my learned friend could show you a clause of this contract which said the parties have to do their best to sort the financing out, you would not be in a position to say that one party was not participating in that properly. And it's not just, and the point that I was going to show you in this passage from Phillips Petroleum is that it's not enough to say, oh well, because they didn't do anything, that must be a breach. So wherever the line lies, there's a breach. The answer in law is there's no enforceable obligation. If you're familiar with that passage, then
whose judgment is it?
That is a judgment of the question. I think it may be is it a deputy? Sorry, Potter, Lord Justice. It may be Mr. Justice Potter, as he was previously. I'll check it. We've got it in the bundle. I wasn't necessarily going to take you to it.
Yes. Oh, yeah.
But it summarises the core solution that the court provides, which is not to say it's very hard to draw the line, but this has got to be over the line, whichever way you look at it. So, for example, that would be the case where, for example, there was an agreement to enter into commercial negotiations and one party just refused to engage. One might say, well, that's so far over the line that it must be a breach. The law's position is that if I can't draw a line, then that's the end of it. There's no enforceability. Yeah, it is Lord Justice Potter. So this is Court of Appeal, is it? It is. Sorry, it's a Court of Appeal decision.
Is it not? It's not reported.
I don't think it is reported. At least we couldn't find a report.
Well, it's some time ago if it's Mark Potter in the Court of Appeal.
Yes.
Yeah. Right.
2000. Sorry, I'm being whispered at. I'll just move on. So that's the second problem. And again, I mean, if my learned friend can't persuade you otherwise, then that's the end of the case. And then the third part of this is that if there is, and this is under the heading duration at paragraph 84 and forwards, if there is an obligation of this sort, it's not infinite. So where there is an obligation to negotiate, it doesn't last forever. And we rely on the decision of the U-Bell, which makes that clear. It's exhausted ultimately, and you can look to that if you like, or I can show you it. But the claimant on this again relies on Asta Management, but again simply takes comments from that case out of context. The point in Asta is not that there's some general rule that these sorts of obligations run and run and run. The relevant part of Asta was dealing with the particular clause in that particular case, and the clause said the deadline date was the 31st of December 2010, and the court found that if that was not practicable, then the deadline was as soon as practicable after that. So there was still a deadline. It was just whatever was practicable. That was in Asta, but that doesn't mean that you don't eventually have to stop. You're not entitled to stop. You don't have to keep going for a decade, which is effectively my learned friend's case.
Well, there's a real oddity here, isn't there? Because if you go back to the original deal, as soon as is reasonably possible after the effective date, and the AJVA, which fixes that as the 5th of May of 2004, on any view, that time would have expired long before 2007, when the parties effectively begin to discuss matters at all. In fact, before these shareholders were ever involved in Hexagon.
Yes.
So the parties then proceed on the basis that, never mind that provision, we're going to sit down and talk and see if we can sort something out.
Yes.
But the question is, what essentially is waived at that point?
But is it though? Because, well, all right, so waiver. What is waived? What would have to be waived? Put it like that. So what would have to be waived is any deadline.
Yes.
It's not, otherwise you'd have to have an amendment of the deadline.
Yes.
And there's no amendment of the deadline. But if you waive any deadline, then again, you end up with an unenforceable obligation. If I say to you, I will provide you with, I mean, if it's genuinely, there is no deadline, I will pay you, but I'm not going to tell you when, and you can never, it's just an unenforceable obligation. I will do this, but sometime in the future.
There was a problem by the time the UBOs came onto the scene, because if you look at this agreement, it envisages everything happening within a very short period of time. And you only have to look at Schedule E and that part of which Mr. Sprange says is really Schedule F, with the all scenarios assumptions on build-up area and total cost and all the rest of it, to realise that they were putting in some assumptions that were expected to apply to a deal that is done there and then, with a shareholders agreement in a matter of weeks and so on and so forth.
Yes.
The problems wouldn't have arisen in one sense in relation to changes in the market and all the rest of it if they got on with things straight away. But we're 2 years down the line.
Yes.
But before these entities, these actual individuals, begin to get to grips with the matter at all. So you've got an inbuilt problem from the start.
Yes. And if one looks at, for example, the costs which are estimated for that project at the time, even on Mr. Williamson's estimates, you know, things are doubling by 2012. It's astronomical increases. So that's why we say, we said from the outset, what this was a deal to do that project then.
Yes.
And that's why it's not surprising that there is no provision, albeit there's allowance, there's no provision requiring anybody to negotiate any kind of a change to that project, let alone change to the financing. It's entirely unremarkable. But if one looks at the sorts of deadlines that might be meant by as soon as reasonably practicable, one has to recall that this contract's put together in 2 phases. So the first one, the requirement is for Nexus to find an investor within 12 months. That's the long stop date. And
where's that?
J5, clause 2.1. And so you've got the operative provisions and so forth will come into effect when the following condition is met, which shall not be more than 12 months from the date hereof. And then the condition precedent itself is relevant as well, because 2.1.1, Nexus shall have identified and the master developer shall have approved an investor who is willing and able to invest.
Yeah.
So the idea is 12 months is the long stop. When you get to the end of 12 months, you should have found someone who is ready to go there and then, get going. And you'll recall at 3.2, originally the deadline was 12 weeks for everything. Yeah. Now that was deleted, so one can see that there's a degree of flexibility that is introduced. But what is replaced by is a series of things, including at 2.5.1 on page J27, the change at 2.4, sorry, page 27, that the parties shall proceed immediately to incorporate the limited liability company. And so, as Your Honour says, this all becomes a serious problem for the claimant in the period for May 2004 to 2006, because the question you have to ask at that stage is, was it reasonably practicable for these parties to do these things in that period? And if the answer to that is yes, well, then the breach has already occurred and the limitation period has begun to run. And if the answer is no, it's not reasonably practicable in the course of 2 years to agree to those things, then the question is this now becoming an infinite obligation? And the answer, as we've seen from the law, is no, it can't be. So then I was going to come on and just deal with breach. We can, unless you'd like, there's any more that you want to deal with.
So far as both the JVA and the amendment are concerned, what's envisaged in reality is taking an off-the-shelf company and then fiddling around with it, because they thought that would be the quickest way to do it.
Correct.
Yeah, and you'd need the SHA, the Shareholders Agreement, to put into effect the terms of the AJVA in terms of shareholdings and contributions and capitalisation.
Correct.
Issue of shares and so on.
Correct.
Yeah.
So you need a shareholders agreement. Would you need that? Would you need that shareholders agreement before you incorporated the company?
No, because you're buying one off the shelf.
Yeah, exactly.
If you buy one off the shelf, you've then got to fiddle around with it. That's all.
Yes.
I mean, getting an off the shelf company is easy. It's even in the DIFC, I suspect.
Yes.
But the question then is, what good does that do you?
Yes.
The answer is none at all, unless you've got something sorted out as to the way it's going to be run, governed, and capitalised.
Yeah, quite. And that's why when I come on to deal with breach, I haven't really focused on that issue. I mean, I'll deal with it in outline, but it becomes important when one gets to the 2008 shareholders agreement, because of course at that stage there may or may not be a case that deal should have been consummated with the creation of a company. And we'll see why that case doesn't actually stack up in any event. But even if it did, it would lead to an interest for CHL and not for Hexagon. But anyway, I'll deal with that, if I may, when I come on to breach. I'm told that it's time for a break for the transcriber. Now would be convenient, if it is for your lordship.
All right, let's take 10 minutes now then. Thank you very much.
Thank you. My lord, I was going to move on and deal with questions of breach. Before I did, we've identified that document that you were referring to.
I can't see you.
I'm just restarting my camera.
Thank you.
Good.
Yes.
I was just going to show you that document that you'd identified. Oh. Your eyes were accurate and better than mine. So it's F333, bundle 1. Should be behind tab 47, tab 47.
Yes. What does it say?
Well, I think the answer is that you're right, and there does seem to have been some sort of connection, but I'm not sure I would use the phrase shrouded in mystery. I would probably say the mists of time rather than mystery, but certainly I can't really help you very much. So you'll see on incorporation, it's in MACPAL, but there is reference then to Nexus in December 2003.
Well, I've assumed it was an off-the-shelf company, and MAPCAL is probably
perhaps
the name then. Nexus then becomes the owner.
Yes.
Then we get. That's December 2003.
And then October 2004.
Nexus Investors Limited then appears. And then David Michael Gorton and Sheikh Juma.
Yes. Albeit David Michael Gorton seems to step out a year later for Nexus Partners again. And then the whole lot.
He's a nominee probably, isn't he?
Well, it may be, or I mean, he perhaps or perhaps not, because there is actually a shareholding split, if you see, between him and Sheikh Juma of 3 and 9 million. See that in the second row. So if he was just a nominee, one wonders why.
No. But if you look, it's Nexus has 3,000 that takes it off him. I mean, it rather looks to me as though Nexus investors, Nexus partners, and David Michael Gorton are probably all emanations of the same shareholder.
Well, not necessarily. I mean, they go back and forth between them.
Yeah,
it may or may not be the case.
Anyway, bottom line is that at one point, it looks as though Sheikh Juma and Nexus have a 75%, 25% interest in Hexagon.
Yes.
And then Sheikh Juma sells on.
Yes, and then he sells them to Ruby Limited, which is where we get the new shareholders.
And Nexus sells to Secure.
Yes.
Which is Al Hussein, whatever his name is.
Yes. What I'd say is that it's not necessarily inconsistent with, I mean, it's hard to know precisely what's going on here, but it's not necessarily
quite late though, isn't it?
Quite.
Nexus is only getting out in August 2005.
Yes. Yes. Correct.
Yeah,
but it's not necessarily inconsistent with the obligations in the JVA, which was for Nexus to go off and find an investor. No. The fact that they hold shares in the vehicle and then sell those shares out doesn't necessarily mean that the plan all along was, for example, that they would control the investor, or the same human beings would control the investor. If you see what I mean. But I take the point.
I would have expected them, because it was expressed in that way, that they weren't going to be in control. They weren't going to be able to provide them. He wasn't going to be able to finance himself. Yes.
Well, I think your lordship's question to me was, does this all affect the construction of the intervention of Nexus in the preparation of the shareholders agreement?
Well, it was just it's not as if you're looking to an objective third party.
Well, that's my point. Because if this is simply the mechanism by which you get to control of Hexagon by an objective third party, then it's the same thing. And so I think this document's consistent with both, and we don't really know what the ultimate backdrop to that all was.
No.
In any event, I was going to move on and deal with breach, which we can pick up in my notes from page 22, section D onwards. As I say, we've tried to focus on obligations in respect of the shareholders agreement, with the exception of looking at, I do look at all the pleaded disputes, but with the exception of looking at particularly the incorporation of the company in 2008. And what we sought to do is break it down into various periods, and we slice it a bit more finely at this stage to really to reflect what we see as being the changing priorities of the parties as time went by. And you've seen enough of the chronology to deal with that. And I've made the point that really the case as opened is this case of some form of deception, not a filibuster. So what we have to look at is the granular allegation of breach, and then whether they support that overarching case, which, as we say, is not pleaded. So the first period we adopt, starting then at paragraph 95, is the early years, which we've just been discussing. So I won't labour that.
Yeah.
But it's been dismissed. Just to add the one point to your lordship's question about waiver, you know what my fundamental point on waiver is. Either it's been waived or it hasn't. Either way, the claim fails. If it hasn't, there's a limitation problem. If it has, there's no enforceable obligation. But just to get to the question of could it have been waived, it's difficult to see how it could without Nexus. I suppose you might say Nexus didn't do anything either. Anyway, I'm not sure. Well, there we go.
Yeah,
Mr. I'm not sure how far we can go with that.
Redpay was dead in 2005 sometime.
Oh, that's true.
Of course, that doesn't mean Nexus is dead, but
no. In any event, I think, yeah. I won't go into waiver too much because we just don't know, and we're speculating at this point. Does the simple passage of time amount to a waiver? Not obviously. You need an unequivocal statement that the parties weren't relying on their contractual rights at a particular time, and simple silence during that period seems unlikely to amount to that. But as I say, if it does, then all bets are off. There's no enforceable time limits at all. What it certainly doesn't mean is it converts it into an obligation forever to do these things.
Well, it would convert it, one would think, into an obligation to do things within a reasonable time, which again you would think would long since have expired by the time you get to any time at all.
Yes, quite. But my point is that if the original deadline was waived, then why would that deadline not be waived by subsequent not doing anything? So then you end up with a no deadline, and that's the problem there. But anyway, I do say though that it is another fundamental point of failure for the claim. The next period is 2006 to 2007, and that's where the amended particulars of claim begins. Now, I've shown you the amended particulars of claim, but I do think it's worth just using it as a reference point, because what I was going to do, and what I've done in the note, is go through the pleaded allegations, and then for each period where they're brought up, try to deal with the unpleaded bits as well, to show you why they don't work. So if we start at A13, just to remind you of the scheme, we see paragraph 19, which sets out what I would describe as the bold assertions of breach, which really are mostly just reciting the relevant clauses and asserting that they were breached. The detail, they then refer back to paragraph 18, if you recall. So we have to start, paragraph 18 starts on page A10. And so each of these facts in paragraphs A all the way through to I are relied on as particulars of breaches of the particular terms of the agreement. So if we go through 18, we get the case as pleaded. Paragraph A deals then with a period for which there really isn't much evidence, which is January 2006 to March 2007. And it said that the claimant, and the real allegation here is that, firstly, the claimant repeatedly called on the defendants to incorporate, and then there's reference to a particular meeting note, which you may recall seeing, and we'll come to in due course, but it's about incorporation of the company. And then at the bottom, on the 16th of December 2006, a draft shareholders agreement was sent. So the way that the allegations are advanced is by reference to things that the claimant did, but we have to imply from that some sort of response was obliged from the defendants. Now, the 16th of December shareholders agreement comes up later, and I'll deal with that when I deal with the shareholders agreement generally. B, though, if we put that together with A, is the 10th of March 2007 communication from Mr. Mukadem to Mr. Ferris, calling on him to incorporate. So save for that December 2006 shareholders agreement draft, which I'll come back to, the pleading up to there is all about incorporation. And Your Honour made the point that there's a difference between the AJVA and the shareholders agreement, because in the AJVA we're contemplating the incorporation of an off-the-shelf company, which anyone can do. Now, during the course of that period, we have a series of unpleaded complaints that have been raised. So I have started dealing with those at paragraph 103 of the note. And largely, there's a series of complaints that were made largely in cross-examination, some of them in opening, some of them in closing. So we try and deal with them all. Firstly, it's alleged that due diligence was sought too late. Do you recall? The point here was that what was being said and suggested in cross-examination was that the defendants were told about the change of control of Hexagon in early 2007, but they never got round to asking about the shareholders for due diligence until early 2006, but they didn't get around to asking about it until December 2006. That was the complaint that was made in Cross on that. And the point here is that there's a document which comes from the claimant itself, which is page 422, which set out the claimant's own chronology of the period. Does your Honour have that? Probably looking at something else though.
I was just looking back at the document we're looking at a moment ago.
The document from 2007.
The F333 document.
Ah. Yes.
Which gives you the November 2006 date as the date when Ruby acquires 3,000.
Yes.
3 million shares, is it? Anyway, well, however many it is.
3 million.
From Secure Investments.
Yes. So you'll see there are transactions in August 2005, and then there's a transaction below Gate Limited August 2006, and then there's another transaction, as you say, the final one for Ruby on the 1st of November 2006.
Yeah.
So just picking up and so the assertion has been that, well, from Mr. Al-Majid in his evidence, was that from the beginning of 2006, and certainly in cross-examination it was suggested from the beginning of 2006, the DIFC was aware of the identity of the new shareholders.
Yeah.
But if we go down, you've got that chronology of the actual share transactions, and if you go down to F422,
that's Mr. Mukadem's history.
Mr. Mukadem's note, exactly.
Yeah.
So item 18 of that says 16 August, we confirmed to the DIFC a significant change in Hexagon ownership and requested a meeting to proceed. And then there is a meeting of sorts. But then item 33 on that list says 6th December meeting took place, it was minuted and final shareholders were declared DIFC. There's also in this context a letter from the DIFC, which is the 21st of December 2006 letter in which these requests were made. That's on page 338.
Yeah.
And you'll see in the first paragraph, it says, in particular, we refer to the letter from you dated 29 August 2006. We haven't seen that letter. Identifying the current shareholders of Hexagon Holdings Limited and the subsequent discussions we have had wherein you indicated that the shareholding had changed.
Yes.
So you'll recall from the various shareholdings, what's happening is there's a gradual process of accumulation of shares by the current Hexagon shareholders. There's then, it appears to be a letter in August saying we've now got control, and that's consistent with Mr. Mukadem's list.
Yeah.
Then you've got a statement that shareholding has changed. Then you've got 6th of December from item 33 on Mr. Mukadem's list is a 6th of December meeting where final shareholders were confirmed. And then you've got a letter that comes on the 21st of December.
Yes. And that fits with F334.
Exactly. Exactly. So you've got, I think it's November, wasn't it? That oh, and then also Mr. Papadopoulos' shares. That must be the Gate ones.
That's
I think
the Gate. Yeah, that's August.
Yeah, August. Sorry, August. Exactly. Yes, you're right.
Yeah, your note fits with F334, as does Mr. Mukadem's.
Yes, thank you.
History.
So the bottom line of that is that there's no delay, and these are all obviously perfectly reasonable requests when faced with new shareholders, new money. Due diligence is required for two broad, important reasons: money laundering and also knowing that the partner has the money. And there was that condition precedent that they were willing and able to invest straight away. On the other hand, we've seen the internal emails around this time. And what you see from those emails is the DIFC effectively giving the claimants a rocket for delay. So the idea that at this time, the DIFC was going slow and Hexagon was trying to push things forward is just totally unreal. It's just not true. Then there's all this stuff about Gensler and the appointment of Gensler. Do you recall that, my lord?
Mm-hmm.
And in relation to Gensler, there seem to be two complaints. One is that the design was approved and then rejected. That's the first complaint. And the other is that Gensler didn't do a good job. So just dealing with the first one, my lord, if you're in Bundle F, Volume 1, if you turn back to page 291, I'll just remind you here.
Yeah.
This is the receipt for the money that was paid, and it's the bottom bit. While remaining amount of 50,000 is to be paid by Tamiat to ECG upon obtaining DIFC-TCOM approval on the architectural preliminary submittal. Yeah. So again, the suggestion that the money was paid after approval is just totally inconsistent with the evidence. And if we go back to Mr. Mukadum's note, item 31 says that it was submitted to the DIFC. It's what it says. It was that the claimant bought the design to submit it. So the idea that it was submitted before then, it is again just totally inconsistent with the evidence. In cross-examination, Your Honour asked my learned friend the question. My learned friend was cross-examining Mr. Barazi on the basis that there had been some formal submission. And I think you said, well, if there is one, you better take him to it. The answer came back from my learned friend, I will. You may recall he never did. That's because it doesn't exist. It's not, well, at least it's not in the bundle. The further point that's raised in relation to Gensler is that they were replaced by Perkins. And the case on that has gone from the opening, which was that the DIFC strongly encouraged the use of Perkins, to closing, which is that the DIFC imposed Perkins and will. There's no evidence of that. And in fact, the evidence is inconsistent with that, whatever it goes. If you find page 574, could be in the next bundle. This is a document that was left off my learned friend's list of relevant documents about the Gensler experience. 574, you see Diaz from Mr. Adil, Mr. Al-Majid. I met with Mr. Adil Abdullah. It's a positive meeting, and we agreed upon, and then you see what was agreed. Tamniat will ask Gensler to do a professional presentation, as well as DIFC will invite their designer to do a professional presentation. Engineering of Tamniat will set together with DIFC engineering team next Thursday to do the best calculation for usage. Within 10 days from today, we should select the conceptual designer. So it looks like what happened was that there was two competing presentations and then a selection. But in any event, in his evidence, Dr. Adil accepted that Perkins were world class. Those were the words that he used. If something went wrong with Perkins, and it's far from clear that anything went wrong with Perkins, rather than just unrealistic developer requirements of 80% and 2 towers. But if anything did go wrong with Perkins, it's just nothing to do with DIFC. One steps back. How does this support an allegation of bad faith? It just got nothing to do with it. As I say, I'll deal with the particular allegation of the December 2006 draft shareholders agreement when I come on to the next phase, which is March 2007 to February 2008. And we deal with, Sorry, I think I put May 2007, but it's March. It's on page 26, and we start at paragraph 114.
Somewhere in your note, I thought there was reference to F574, but I can't now find it.
In my note, there is, I think.
It doesn't appear in 110, 11, 12, which is where I'd expect it to appear. But anyway, there it is. Perhaps it comes later.
Sorry, paragraph 22. Oh, it's earlier in the discussion, the general discussion of the evidence. I'm afraid it's up at 22.3.
Oh, right. Thank you. Let me just cross-reference that. Oh, yeah.
This was making the point that in the course of cross-examination of Mr. Barazzi, quite a lot of points were put which were either disputed or not borne out by the documents. And that's really to make the point that when it comes to Mr. Barazzi's evidence, one just has to bear in mind it's quite easy to get lost in those sorts of questions. Not that I say that he did, but there we are. All right, so I was going to move on then to the next phase, which was 06 to March 2007. No. March 2007 to February 2008. Thank you. And this is dealt with in the amended particulars of claim. If you still have those open, it's C all the way through to F. I don't think I need to take you through the detail of those, but what is being alleged is, in effect, certain facts about the negotiation of the 2008 Shareholders Agreement. So C, for example, you'll see there's an allegation in there that of an email which refers to a draft shareholders agreement which was prepared a long time ago. Do you see that at C? Well, it's the bit in italics. Now, that is the email that is dated 16. Sorry, that's the shareholders agreement that was dated 16 December 2006. So there was that draft from 16 December 2006. But what C here does not point out is that in the very same email, the 8th of May 2007 email, it goes on to say it obviously needs substantial amendment in light of the agreement between the parties. And this actually is the beginning of the negotiation of the shareholders agreement. So the rest of the complaints, all the way down, in fact, to G, are all about, or F at least, are all about that process. Now, we say this is very obviously a negotiation of a very different agreement. My learned friend, sorry, you're on mute, my lord.
In the documents, the agreement that Mr. Barazzi reaches on the 27th of March 2007 almost comes out of the blue, as recorded in relation to the built-up area and the shareholdings. But there must have been preliminaries to that in terms of discussion and negotiation. That's reflected in the CHL agreement in 2008. But it's much before that, isn't it?
We say it must have started before. I don't know exactly when it started, but
No.
But clearly there's a gap. So there's a draft shareholders agreement is sent in December 2016.
Yeah.
And then we see in March 2007 or May 2007 reference to that agreement and saying that it needs amendment in light of our discussions. So it is not clear what happened and when between those two dates. That much on the evidence I accept. It's not clear why and where the parties agreed to take a different course. But what's clear though is that they did. And so they decided to do various things, obviously replace the claimant with a new entity, change the size of the project, change the shareholdings, and change the financial arrangements. And that happens in stages over the course of that whole period.
Yeah, my point is, if you go back to F495 and what I'm inviting your comment on, is that on the 25th of April, I got the date wrong, I thought it was March 2007, but 25th of April,
Yeah.
2007, we've got Barazzi referring to a meeting and confirming the increase in the built-up area and the change in shareholdings. So in reality, it's self-evident that between December 2006 and April 2007, there had been some discussions and negotiation that led to a meeting and an agreement.
Yes. Yes.
Whether or not the December 2006 draft shareholders agreement was sent, it's tolerably plain they were discussing fairly important matters.
Yes, they were having discussions, exactly, which were going to change the whole shape of the transaction.
Yeah.
So clearly, it's rather difficult, it seems to me, for my learned friend to assert the case that there's some breach of agreement to, sorry, a breach of obligation to agree or negotiate the particular shareholders agreement that had been sent out in draft in December, if that's when it was sent. I mean, all that I was saying was simply that while one sees during the intervening period discussion about proof of purchase, proof of shareholdings and all the rest of it, we don't really have any insight into precisely when those discussions took place from the documents. But these substantial differences, we say, mean that what was then being negotiated was something that was a departure from the joint venture agreement. And so why is that important? Well, the question then becomes, assume that there is some obligation to negotiate a shareholders agreement under the JVA. It can't be an obligation to negotiate this agreement. So any deficiencies in the negotiation of this agreement couldn't amount to a breach of the JVA. That's the point. And my learned friend says, well, the difference in the party is just irrelevant. It's just a nominee, and there was some evidence about it being a nominee, which fell apart really on cross-examination, because the individuals accepted that, as far as they were aware, there was no arrangement between Hexagon and CHL, so it's not a trust type scenario. There's no contract in the background. It is just a replacement contract. So, I mean, and as I said previously, arguably, if the 2008 shareholders agreement had become binding, the effect of that would be a fundamental and complete breach of the defendant's obligations to the Nexus and Hexagon under the terms of the joint venture agreement. If I agree with one party that I'm going to let them develop a plot, and then I agree with another party that I'm going to let them develop a plot, the same plot, then the second agreement is wholly inconsistent with the first, and therefore I am in breach of the first. And what that tells you is that I can't be in breach of the first agreement by failing to use reasonable endeavours to agree the second. There's also clearly, we say, a material change to the financing during that period, and you were taken to some aspects of the 2008 shareholders agreement. I can show you them again if you like. It's at Bundle J, page 44. I'll just show you two snippets. And it's 7.1.2. CHL reserves the right to obtain in the name of the company at the cost of CHL such funding as it shall require to ensure that it meets its obligation to provide the company with project capital and working capital, and includes security over the land. So it's not just, and there's been a lot of focus over security, and that is obviously a material change, but it's not just that. It's just it gives CHL the right to meet its funding obligations through shareholder loans, through loans by the joint venture company, which of course is going to then dilute the value of the shareholder company.
Well, it doesn't quite do that, does it? As I read it, it allows the land to be used as security for both project capital and working capital, but the joint venture company itself can only borrow in respect of working capital, not project capital. See the following line. bottom of 7.1.2.
Perhaps I'm misreading it then, because I'd understood it says CHL reserves the right to obtain in the name of the company.
Yes, but if it go on, provided that no part of the project capital shall be borrowed by the company, whether from CHL or otherwise. And that's the difference between this version of
Oh, I
events.
see. I'm so sorry.
And then when one goes on to the 2010 memorandum and the 2012 memorandum, which gives them a total liberty to get everything by way of loans. Here, they're only entitled to the joint venture company can only borrow for the working capital, but CHL can borrow against the security of the land for the project capital.
Yes, yes, that's right. And they also have the upfront obligation to provide the 98 million.
Yes.
Yeah.
Yes.
But then they also get the benefit of the off-plan sales.
Yes.
That's 711.
Yeah. No, I've got.
So you're right. It's a different structure. Sorry, but it's an amendment.
Yes.
And depending on what's generated by off-plan sales, if you assume the costs are broadly the same as are required for the project that we've been looking at, to around 200 million, then what you've got is something like a half up front in liquid capital cash from Hexagon, plus off-plan sales, plus the ability to raise capital from mortgaging the land.
Where's the 98 million?
So we see that on page 39. And then over the page. So you'll recall what happens is it says,
yes.
Sorry, you've got the upfront 221 and then the.
I was just checking the currency, that was all, yeah.
Yeah.
Thank you.
If that's right, there can't be any breach of the JVA in relation to the negotiation of this. Now we say that there was no breach, no delay. If we start with that low bar in the duty to negotiate, or rather, to put it like this, it's just your Honour's just not in a position on the state of the evidence to say that if there was delay, it was the fault of the defendants. So assume that there was some sort of duty to negotiate, otherwise we don't get started on this. How are you going to be able to say that the defendants should have given ground on one or other commercial issue more quickly, which is effectively what the case would have to be? We don't even really see on the face of the documents where those critical agreements were struck. Some of the criticism, and we deal with this at paragraph 120, some of the delays that are asserted, we say, are plainly overblown. So in cross-examination, for example, it was suggested that between April and June 2007, the shareholders agreement had been with the defendants for months, was how it was put. The document itself, as you can see from 120 subparagraph 2, said that the shareholders agreement is with the legal department of DIFC for more than 2 weeks. And so there's back and forth, which isn't properly documented in the papers that you have. And it's just really, you're not in a position to make an assessment, 15 years, 16 years later. The bottom line is there were still commercial negotiations going on in December 2007. And you have that at page 850. Of the bundle. And then there's further details. I can take you to it if you like, my lord. You've got the references, but there were further details that were being negotiated subsequently in January 2008. Now, so we say there's no delay. There's just a negotiation going on, and yes, it takes time. The DIFC. Where does this go if it's alleged that this goes to bad faith, deliberate delay? What's relevant here? There's a document at page 628 which shows the DIFC is chasing internally. So you see Mr. Dean Ferris at page 628 chasing internally, saying this is now a real urgency. So And you heard, I think, Mr. Barazzi's evidence that the DIFC legal department was overstretched during this period. So if there is delay, it's not redolent of bad faith. And chasing internally is consistent with good faith, as is the fact that the defendants ultimately did agree and did sign the agreement. Now, of course, if one starts to see the world through the lens that this is all some sort of giant conspiracy, then all of that can be explained away, but it becomes less and less probable and more of a conspiracy if you have to start explaining away things like the head of legal department chasing his own lawyers to speed up negotiations. All right, so I didn't want to say an awful lot more about that period. I was going to move on and talk about the next period, which is February 2008 to December 2009. This period gets pretty busy with allegations, pleaded and unpleaded. So starting with the pleaded allegations, we see that at A12. They're in 18G and 18H. And these refer to two things. The first is the obligation under the Shareholders Agreement, or the expectation under the Shareholders Agreement to incorporate a company. And then the second, as you see from H, is the email of Mr. El Fadil on the 31st of December 2009. So I'll come to that at the end. Now, just dealing with the question of the Shareholders Agreement, you asked the question of my learned friend, what is the case on whether the parties were proceeding on the basis of whether it was binding or not? Did the parties think that the SHA was binding? And Your Honour was told, I think, that the witness, what some of the witnesses for the claimant had said about this, and this is, I have got the references here. Mr. Al-Majid had said it wasn't binding in writing, or he hadn't thought it was binding. He called it deliberately throughout a draft shareholders agreement. He's very careful. So if you see, for example, I'll give you the reference, page D26, he's quite careful throughout to call it draft. And you'll recall Mr. Ali's email that I took you to from 2013, and you might join the dots between the two, that there was an attempt or a concern not to give the impression that they considered the shareholders agreement to be binding, because the effect of that, of course, was to terminate, or purport to terminate, might be to terminate the joint venture agreement. That was the concern. Now, in oral evidence, Mr. Al-Majid conceded that he thought that it was binding. And if you have the transcripts bundle available to you, you will see that at page 131 of that bundle.
Can you give me the day reference? I mean, I'd
Yes,
marked up separate transcripts before.
Understood.
The
It's
bundle
day 3.
light. So what
Day
are we looking at? Day 3, yes.
Yeah, day 3, page 35.
Thank you.
And it's line 10, it starts.
Yeah.
And if you read down to page 36, line 10.
Yes.
Yeah, so he conceded that, or line 9 it goes down to, which we say is obviously a significant change from his written evidence. Mr. El Fadil, unfortunately, clearly hadn't got the memo, and said, we say quite incredibly, that he considered it was a nullity all through because Nexus and Hexagon didn't sign it. So that is my page 213. It's day 4. And he says it in multiple places, but if we start on page 101, day 4,
yeah,
and line 5 to 15. Is that right? Yes.
Yeah.
So when one comes to Mr. El-Fadl's credibility, that we say is a pretty key bit of evidence, key bit of testimony under oath. There's another point on page, same day, 107, where he says it again at lines 13 to 17. Denies it. What's clear then is that everybody thought that the joint venture, the shareholders agreement, was binding. What I'd say is that the claimant's case as to why it isn't binding has changed quite considerably. So you hear Mr. El-Majid saying it's not binding because of Nexus and the Hexagon not signing it. You'll recall from the 2012 memo, that was also the position there. But now it's said in the claim that the reason that the ESHA wasn't binding was because the company that was anticipated to be created wasn't incorporated. And that's changed over the course of the claim. And we recite that at paragraph 127. As to what actually held up incorporation, it's difficult to tell. It's rather like the agreement of the shareholders agreement. You're not terribly well placed to decide that point. The most likely answer, the headline that we would give, is that the incorporation of the company was just not a priority until things became more advanced. And by the time that they had done so, the global financial crisis had become really the priority. So we've also, of course, got a series of different explanations as to why CHL, because it was CHL that was the counterparty, could not itself simply incorporate the joint venture company. And sorry, those are the ones that we deal with at paragraph 127. We say none of them has any real substance at this point. In terms of the story itself, the bits that my learned friend missed out, because he took you through some of these documents about the incorporation, the fact that it took a very long time, and he said it was clearly anticipated that the defendants would be the ones to incorporate. If you have bundle F, we can just see that that is wrong. If we go, please, to page 1476, which you'll find in volume 4. And this is amongst the draft documents that were prepared.
Bundle 3, I think.
Oh, sorry.
1476.
You're absolutely right. Sorry, 1476. So this is a board resolution that is attached to the draft Articles of Association. We, the undersigned directors, and you'll see reference to Concept Holdings Limited is the company.
Right, bear with me. Oh, yes.
So Concept Holding Limited is defined as the company and resolves that the company incorporate in the DIFC, insert NUCO name in the DIFC. So clearly, the proposal, you see, resolved that Suleiman Abdul Al-Majid is hereby appointed and authorised to execute all documents and take all necessary and appropriate actions on behalf of this company to incorporate insert NUCO name. And Suleiman Al-Majid is hereby appointed and authorised to execute all documents and take all necessary appropriate actions on behalf of the company following incorporation. So the submission, and you'll see that's to be signed as a resolution of Concept Holdings by its directors, Suleiman Al-Majid and Mr. Papadopoulos. So the submission that it was always anticipated that the DIFC would do that is just simply wrong.
This is during the course of negotiating the Articles of Association.
Correct. This is at an earlier stage. So
this is 20. Where is it?
Yeah,
March 2009.
Yes. So if you have paragraph 129 of my closing, you'll see what we set out as being the relevant chronology. And so there's actually no pleaded complaint about this period, but in any event, 192 CHL, 1292 CHL contacted the DIFC on 20th of February 2008 about the forms required. The defendants responded immediately, and then drafts are presented in February 2009. And what and why there was a delay between, we don't have a clear insight into, but I would say on the probabilities, the likelihood is it just wasn't a priority. There were other things that were more important. As you recall, the concept design was on the rocks at this point. At the end of that chronology, you'll see you get to that 31st of December 2009 email. And this is the next pleaded complaint about incorporation of the company. This is the one where Mr. Al-Fadl points out that it's not healthy for anyone that the joint venture company has not been incorporated. Now, quite what was going on with that email is difficult to understand, given that less than a month later, as you see from paragraph 1297, on the 26th of January, you have Mr. Jawed Ali emailing to say that he wanted to discuss the structure of the investment, the capitalization of the NewCo, and so forth. And then shortly after that, in 2010, you have the memorandum that says the shareholders agreement needs significant revision to remove Concept Holdings from the structure. So why is there an email being sent shortly before this saying, gosh, it's terribly unfortunate that we haven't incorporated this company, we ought to get on with it? There are two possible solutions to that question, it seems to me. Either A, there is a significant disconnect between Mr. Al-Fadl and everything else that's going on inside Hexagon, or B, and this we say is the more probable answer, this is just pure paper trail. And having heard from Mr. Al-Fadl, I would suggest that is the more likely solution. So what the documents show through those discussions, you've got some of the references there, is that the parties are negotiating those documents. Then the crisis strikes and the claimant and its backers start assessing their options. So during this period, there really make 2 points. Firstly, I've said this previously, that there's clearly a lot more going on behind the scenes on Hexagon's side of the fence than they are letting on. I'll come back to that in a bit. But the other part is, and it's admitted it seems, the claimant clearly changed its mind about the shareholders agreement. We see that from the external and the internal documents, because it doesn't want Concept Holdings in that structure anymore, and we'll see when we come onto it, there's this change in the financing approach. When and why that decision was taken is not revealed to you. And I'll come back onto that in the next phase when I deal with the two memoranda, which are the next two substantial breaches that are alleged in the pleadings. Before I go on to the memoranda, and those are probably the most important bits of all of this, I just want to deal with the 3 complaints that are made in this period. So you'll recall from the evidence and the cross-examination, there were 3 complaints about the affection plan, the GFA, and the use mix. On the affection plan, I had thought that Dr. Adil had basically conceded that, yes, it took time to get the affection plan, but he couldn't say why it took time. And you've heard from Mr. Barazi, his evidence wasn't really challenged on this. His evidence was it wasn't up to us. It was up to the RTA. And by the way, we negotiated a concession to reduce the width of the road by 1/3, from 18 to 12 meters. That's hardly redolent of bad faith. It's good faith. They're trying to solve problems for the project, not put up roadblocks. The complaint in closing was that there was no transparency in relation to that process. That was the word that was used. I personally don't know, I don't really understand that submission. It doesn't seem to be the case that they say they wanted to join in the negotiations with the RTA, and that certainly Dr. Adel thought it was obvious that he wasn't involved and wouldn't be involved in those negotiations. In terms of transparency, what else is there other than access to those negotiations? I make the point that when they received the affection plan, Hexagon received it directly from TCOM. So there couldn't be any allegation that the DIFC held this up. So there's nothing in that complaint. In relation to GFA and BUA, we say that the complaint was put, this is at paragraph 136 of our notes. We say the complaint was put in cross-examination in a way that was completely misguided. What actually happened is that the 2008 Shareholders Agreement provided for BUA. There was then a side agreement that BUA could be purchased at market rates for a period. And as we all now know, GFA is bigger than BUA.
One way around, isn't it?
Sorry, no, well, GFA implies more BUA, is what I mean.
That's not what you're saying here, is it? It's vice versa, isn't it? BUA is larger than GFA.
Yes, I think what I mean is, and this is the danger of short form submissions in closing notes. What I mean is, if you have an agreement for 1 million GFA, that's going to be bigger than an agreement for 1 million BUA. That's why I say GFA is bigger than BUA.
Right.
So the BUA will always be bigger, but as long as you understand what I'm saying, then you can put a line through that. That's the point, though, because the agreement was for 1.75 BUA, million BUA. And so when that was identified, there's an internal inquiry. You see this, I've got the notes are in my submissions at little paragraph, subparagraph 5. So there's an internal inquiry in late August 2008. There's a little bit of a delay while they work out what was actually agreed. And then eventually, in the middle of September, Concept Holdings writes to the DIFC asking for an increase in size. And 6 weeks later, they get an increase in size for free. And the complaint is literally, you gave us something extra, which was valuable, for free, but you did it too slowly. It's remarkable, but that is nevertheless an allegation of bad faith. And the mixed use issue is not far off that. Subject to one point, Dr. Adil agreed that the DIFC's position was totally reasonable, which was throughout to stick to the master plan. That point is that Dr. Adil thought that there had been an agreement to 88% officers. You'll recall that. So there is this factual issue about whether or not in April 2008 there was agreement to 88% officers. Now, you heard from Mr. Barazi on that. He was absolutely clear. He would never have agreed to something so far away from the master plan. He couldn't have done so, he said. He was not authorised to do so. Now, this agreement, it is said, was struck between Mr. Barazi and Mr. Suleiman Al-Majid. And all you have from that side is an email saying that that is what had happened in April 2008. But you have inconsistent accounts, both of when the agreement was struck and also of what agreement was struck. As to the latter point, if you were to pick up, I'm going to try not to get this wrong, I think this one is volume 4 of bundle F now, page 1670. And you see there 1670, it's part of that presentation that was prepared in December 2009. And you'll see final bullet point there. The GFA was increased by 200,000. And the verbal promise was that CHL are free to decide the use mix. In closing, my learned friend suggested that somehow Mr. Al-Najjar might have some evidence to say about this, but as I understand it, it's alleged that this agreement was struck between Mr. Barazi and Mr. Suleiman Al-Majid, who of course isn't here. What we say about this is, you've heard Mr. Barazi. He said, had they said 88%, he would have immediately come back and said, no, absolutely not. We did not agree to that. But because they didn't say that, he was picking his battles. And he said anything that we would have agreed on this would have been in writing. You don't have Mr. Suleiman Al-Majid to tell you otherwise. But what is this? One has to step back again from this allegation. What is the allegation? The allegation is that the DIFC agreed orally to something in April 2008 and then went back on it in May. How is that redolent of a bad faith plan to pretend to negotiate when you're not doing it? Why would they agree to anything in April 2008 if that was their plan? And why would they give it up for free, which is what they did at the end of that process? And again, that's why I say it's similar to the GFA point. Concept Holdings got what it wanted in the end. It just kept asking for the mix that it wanted, and the mix that it wanted changed over time because of the need to change it for the automated parking. So it went from 88% down to 66%, but ultimately it got what it wanted. And its complaint is, well, it didn't get it soon enough. And then the other point is, all right, assume that there is some overarching plan. Why would the DIFC feel the need to implement that plan through something like this, when throughout this period, the concept design was on the rocks? I take your lordship's point, well, it could still be, even if it didn't cause a delay, it could be redolent of bad faith. But one has to see it from the DIFC's perspective. If they know that the project is on the rocks from the delays in relation to the concept design, why would they cook up some wheeze about agreeing a mix and then departing from it and then agreeing to it subsequently? None of it makes any sense. And as I say, the reality is actually Mr. Suleiman Al-Majid wasn't fixed on a mixed use at all. It wasn't just the DIFC who didn't want automated parking. Mr. Suleiman Al-Majid did not want automated parking. Automated parking meant 88%. So even if there had been any agreement, he was very quickly seeking to depart from that agreement himself. So that's all I wanted to say about that period and those particular discrete allegations. And then the next period we get to, the final two pleaded allegations, are the allegations in relation to the 2010 memorandum and the 2012 memorandum. And this, we say, is where context is important to discuss what the proposals and the duties actually were at this point. And my learned friend's submission in closing is that by this point there were only some minor matters left for discussion. So I got him at page 20 from yesterday, at line 13, saying, and you have us presenting proposals for moving forward the last remaining aspects of the parties' obligations that haven't been performed and not getting answers. So he suggests, in outline, that these proposals are simply about swapping Hexagon for Concept Holdings and then getting on with the incorporation and the land transfer. And that, with respect, is just totally unreal. So what I was proposing to do was just collect together what we know about what was going on at this point and what it is clear Hexagon's not telling us about. So point one, there's a financial crisis in full swing. We know at this point it's getting into mid to late 2009. There's a bailout going on in Dubai, and we know that the crisis has wreaked absolute havoc within Tamniat International. Your lordship's seen the business plan, which showed serious problems and a major change in the financial strategy of Tamniat. It is worth looking at that document briefly. It's at tab 199 in volume 3, page 1549. So Tamniat International Business Plan and Strategies. This is September 2009. So crisis now in full flight. And this is 2 or 3 months before the December 2010 memorandum. 1552, if I can ask you to look at that, please. We can see key findings on the right under the second row. although it says projects are all viable, it says cash flow management is tight but manageable. Contractor funding is the key element. And then final bullet, management of liability is also very key. And then under key focus, number 1, reduce, eliminate total project liabilities of 1.5 billion dirham. Now, Mr. Al-Majid tried to explain that away, but liabilities are financial obligations. And so clearly they had those financial obligations and they were trying to get rid of them. To return all projects to be viable and profitable. Number 3, to reduce and eliminate cash injection by the group and sound cash flow management, and to rebuild. And then across to the next column, all liabilities will be eliminated except for legal cases, which we hope to eliminate as well. All projects are at least break even or may turn profitable. Overall profitability is improved, and then cash requirement can be eliminated. And if we go down, you'll recall that Mr. Al-Majid tried to say that this was perhaps not to do with the DIFC, but there's actually a distinct slide in relation to the DIFC, which you'll find at 1564. But the bit I wanted to show you, just remind you about, is 1574. Recalling that we're in September 2009, 1574, paragraph 1, to phase out, do you see that? To phase out the development companies and eventual closing down, brackets, Tamniat Sharjah, the Chance Court, Forum Limited, Concept Holdings Limited. So bear in mind, this is 3 months before Mr. Al-Fadl sends his email on the 31st of December 2009 saying, let's incorporate. So it's impossible to avoid the conclusion that that email was really about keeping the DIFC warm. We don't know why there was this plan to shut down CHL. What we do know is, as we saw from that email, and I won't take you back to it unless you'd like to see it from Mr. Ali, but there was some arrangement between Concept Holdings and Sheikh Mana. My learned friend has said nothing whatsoever about this. I don't criticise him for that. The likelihood is constrained in what he's able to tell you. The witnesses, though, I would suggest, were less than frank about this. You may recall.
What date was that?
2013.
Right. So it's a lot later.
That the email comes a lot later, but we don't know. We don't know when that happens. And the reason the email comes later is because that just happens to be one of the only internal emails on the topic that we have seen. But we can see from this document that Concept Holdings Limited is to be shut down or phased out and phased out. We know that at some stage there's an arrangement entered into between Sheikh Mana. When I asked Mr. Hossan about it, he initially pretended not to have heard of Sheikh Mana. So there is part of this that is being concealed from you. We don't know where it goes precisely, but there is something going on behind the scenes there. In terms of external funding, we know that the Bear Stearns discussions have obviously come to an end by now. Bear Stearns famously did not survive the crash. And then there are all these allegations about discussions that took place with CSI. And again, you are not getting the full story of this. What there is clearly, and if we go back in the bundle to page 1542, we see it there, is some sort of consortium being considered. So under the heading DIFC project, 2 down, Tamni had asked CSI to fully fund the DIFC project and to provide all the details involved, and all these details should be negotiated without the involvement of DIFC. So there's a plan to keep DIFC out of it at that point. CSI suggests converting 39% share into floors, and so on. So there's quite a different project being considered, or a different arrangement, which would have required some sort of amendment to the terms of the JVA. It just was not consistent, could not fit within the terms of the JVA. Now, as I say, Mr. Al-Majid said that these discussions ended because the defendants renounced, amongst other things. And even in my learned friend's submissions, his complaint was that by 2012, the defendants had not commented on the CSI design. Does your lordship recall that submission? But what we know from the claimant's own documents is that CSI, the relationship with CSI was terminated long before 2012, because we see it from page 1775.
And the date of that?
This particular document is dated 15 February 2012. But I can show you why I put the dots together on this, because we don't have the story from the other side. By 2012, February 2012, this is an internal version, 1775.
How do we know this is an internal version?
How do we know? Good question. I think this is simply by reference to how these are referred to in the witness statements, my lord. There are various versions. I can track that down for you if you like. The point is that this particular slide appears in the internal version, but not in the version that went to the DIFC.
Well, I saw you said that, but I was unaware.
I'll have to check the references over lunch. Yeah, I'll check those references over lunch. Thank you. But the key, I mean, for the purposes of this submission, what's important is that this is a document that comes from the claimant.
Yeah.
CSI proposed to fund the project and in return be given some units. The funding structure did not materialise and CSI were terminated. All right. And Mr. Al-Fadl said, well, perhaps the funding structure was one that the defendants were supposed to produce. But by that point, I'm afraid he was just inventing facts, because if we go back in the bundle to 1645, we see what's happening, or some of what's happening. We don't see it all.
Yeah.
Sorry, we should still be in volume 4, I think, but
yeah.
You've got an email from Dr. Adele to the chairman and Mr. Al-Fadil. This is 14th of December 2009 now, and what it says at the bottom is, I met Dr. Wan earlier this afternoon and he is telling me that CSI are waiting for JLL to submit their feasibility study, which should include a cash flow, before they can finalise the funding structure. So that's what's holding up the funding structure. It didn't materialise, but we know when it was expected, because it's imminent in the middle of December. We don't know exactly what happened next. We do know that the JLL feasibility report arrived in December at some point. So either there is some discussion between CSI and CHL and Hexagon that we haven't seen, or there were no documents, there were no discussions. But either way, most likely they saw the JLL report and they walked. That just seems to be the obvious solution. It's got nothing to do with the defendants at this stage. And it's quite clear that they were terminated because they didn't produce a structure, and they were expected to produce a structure in late 2009. So the submission, from which it was implicit that CSI was still on the scene in 2012, can't be sustained. Now, Hexagon's chosen not to explain this, but instead has chosen to give the impression that the relationship continued, which it did not. And I'd ask you to bear that in mind when you ask yourself the question, was there a design at this stage? And we've seen one page, one picture of a building that was produced. Was there actually likely to have been a design? When one thinks about it, it seems highly unlikely that anything of real value would simply have been handed over if CSI was not committed to taking the relationship forward. So it's clearly, in terms of funding, there are no leads in late 2009, by the end of 2009. Now, Mr. El Fadil, as I've noted a couple of times already, and I don't want to labour the point, has accepted that times had changed and 100% liquid finance was not foreseeable. And that means that Hexagon and CHL were not going to do the funding the way that it was required in the JVA. That much is admitted. Now, it's in the context of all of that that we get these emails from Mr. Ali saying, let's discuss the structure. And that is the context in which one has to consider what is being proposed. And we start that, we've recited some of the text because it's quite important. We start that at paragraph 166 of our submissions. 167. And just to take you through that briefly, you get the 26th of, if you have that on, I'll do it by submission unless you'd like me to take you to the documents. The references are all in the notes. You see 26th January 2010, Mr. Ali says the investors would like to discuss the structure of the investment in general, the capitalisation of the new co, the transfer of the property and other related matters regarding the joint venture and the development of the projects. The response comes back from the DIFC that the meeting should be to complete the required legal documentation. And there's pushback. Mr. Ali's response is, you're right. However, there are a number of issues of business and commercial issues which will affect the structure, documentation and process of completing the same. And so business representatives have to come as well. So it's quite clear that in the run up to the meeting, and we don't have any allegations about the meeting, we have allegations about the memorandum that follows the meeting, but in the run up to the meeting, it's a business discussion, it's not a legal discussion. And then you get the 2010 and the 2012 memoranda. If we go to those in bundle J, tab 4, start obviously at page 61. On page 62, there is this proposed change back to, quotes, the structure of the JVA, in the sense that it will be Hexagon and not CHL. But then on 63, we have the critical differences on financing. Hexagon will be responsible for contributing the equity portion of the total cost of the project and procuring financing on behalf of the project company. Hexagon may contribute such equity portion by way of additional equity, shareholder loans, or a combination of both, as Hexagon deems appropriate. So first, there must have been a decision to step away from the shareholders agreement by this point. We see this change in how they approach the shareholders agreement. They go from treating it at this point in 2010 as being binding but in need of agreement to 2012 when they say it isn't. None of that's explained to you. But when you ask yourself the critical questions about this memorandum, it seems to me the first question is this a proposal that is consistent with the amended JVA? Now, in relation to these 2 points, the claimants made a fist of saying that the first part of it is consistent, procuring financing on behalf of the project company. The suggestion was that might include Hexagon going off and getting its own financing. That's not what that means. It's a different suggestion. Any suggestion that the context might have indicated something different is countermanded by all of the background facts that I've mentioned. But the second part of it, the ability to fund by shareholders' loans as Hexagon deems appropriate, clearly is not consistent with the joint venture agreement. So then the second question is is it within the scope of anything that was up for negotiation in the joint venture agreement at all? And we say no, it contravenes the fixed parts of the Schedule D, paragraph 6 that we discussed. The third question then is there then some duty to vary it? Answer no, on construction and on the law. And then on the fourth, if there was some such duty, would it be enforceable? Answer no, because it would be a commercial negotiation between the parties for which you have no yardstick. But assume I'm wrong. Assume this is just saying, let's get on with the joint venture agreement. It's still then not a breach of contract for the defendants to simply not engage in this. And that's for a number of reasons. First, assume on that premise, this is simply a document saying, let's get on with the joint venture agreement. This document is not actually doing anything. It's not doing any work. But no draft agreement is presented. And so if one goes back to what Mrs. Justice Andrews said in Danny Lyons, there's no object for discussion. There's nothing on the table. There's no certainty of object. Secondly, it's not from Nexus. There's nothing to consider, approve, and execute. And so effectively, if this memo genuinely was just consistent with the terms of the JVA, all it does is say, let's get on with it. And that is not a contractually significant event. It doesn't take anything further than the JVA itself. And the second part of this is just the point that I made at the outset on the law, which is that these sorts of obligations are not infinite. We are now 6 years past 2004, the amendment of the JVA. There have been endless negotiations producing the 2008 Shareholders Agreement. And what my learned friend has to be saying is that the claimant's now coming back to the table after the change in the world, saying, we want to go back to the start of that process and just start over again. At that point, even if that was what accurate description of what was going on, the defendants would be able to say, well, that we've made our reasonable efforts to agree something. Enough is enough. Now, after this, nothing happens at all until 2012. There's nothing happens, as your lordship observed, in 2011. So when we get to the 2012 memorandum, then the situation is certainly no better, and we say, in fact, the situation is significantly worse. Now, of course, your lordship knows the 2012 memorandum is the focus of the only allegation of breach of contract within the relevant limitation period. That's why it's important. And so is it a breach of the agreement not to respond to that memorandum positively? And by the time you get to the 2012 memorandum, which is in identical terms, save for one or two changes about the validity of the shareholders agreement, you have all of the problems that I've identified in relation to the 2010 memo, but you've got two more problems. The two more problems are, firstly, you're now another 2 years down the track with nothing whatsoever happening in between. So there's nothing happened in 2011. We're now 8 years on from the original contract. And it's not just the fact of the passage of time, it's the inaction in the meantime. And then the claimant comes back and says, well, let's start over. The joint venture agreement remains binding in principle, but the content of the duties doesn't require any more action, because if there was some sort of duty to negotiate, that obligation has been exhausted. We've done it. We did it with the 2008 Shareholders Agreement, and we can't go on forever. But the second problem is that it's in identical terms to the 2010 memorandum. So if the 2012 memorandum was a breach, logically, so was the response to the 2010 memorandum. And refusing or failing to cure a breach is not a fresh breach. So that is why we say the case on breach just cannot work. After this period, we get to the so-called renunciation. I wasn't going to deal with that in any great detail, other than to say, yes, thank you, other than to say that it's only a renunciation if there are outstanding obligations left alive, things to do, and we say there are not for the reasons I've given. And then there is this extended period of negotiation between the parties. The claimant's case is that there were a series of breaches by denying that the contract was binding. So you get this factual allegation about what happened next. On the facts, we say it's wrong, but even if it was right that there were statements to that effect, they wouldn't be breaches, they would be renunciations. They'd be relevant to the question probably of what happened at the end on renunciation, but they wouldn't amount to breaches. So the only allegations of breaches that can really make any sense at all are the ones I've taken you through, and those are the ones that I've now dealt with. My Lord, I was going to move on and deal with the question of affirmation and reasonable time. It's 4 minutes to 12 here in Dubai, and I know that there's a lunch break due. I'm making reasonably good progress. I'm probably 2/3 of the way through what I have to say, so I might be another hour and a quarter.
All right, should we take 3/4 of an hour now?
Thank you.
Thank you very much. Right.
Thank you, my Lord. All right, so I dealt with what we say about breach. I was going to move on to these questions of affirmation and reasonable time. And my learned friend spent a bit of time in opening and again in closing on the question of affirmation. But what he has said nothing about at all is the statutory test that we rely on in the alternative, which is a reasonable time. Just dealing with them in turn, and you'll see this starting at paragraph 186 of our note. Even on affirmation, long periods of silence are going to be enough to amount to affirmation in English law. And we've set out some of the authorities on which we rely, but I don't think that that is a terribly controversial proposition. And then we've also set out reference to the passage in Mr. Justice Foxton's decision in the SK shipping case, which is one of the more recent cases on this, paragraph 188, where he looks at the interaction between reservations of rights and affirmation. And I would summarize it by saying that he effectively finds that even a reservation of rights is not going to last forever. And ultimately, you need to look at the party's conduct. In this case, one has to consider what are the reservations of rights that are relied on. What I do, just to shortcut this, is take it from my learned friend's opening. Now, I recognise that that is not a document you looked at for a little bit of time, so it may take a while for you to turn it up. But if you have it and can find it, and turn to page 17 of that, it sets out the documents and the dates of the reservations of rights. I can give you the dates and read them into the transcript if you like, or we can look at them.
Yeah.
So paragraph 29, you've got Hexagon sought information on the 13th of August. So there's that letter where they don't reserve rights, but they say they're just looking for information. So even if you assume that that is not a reservation of rights, what are the letters where they do? After receiving the response, you see they refer to the letter of the 2nd of September 2012. So that's the first one. And there are 4 more. So there's a total of 5 that they refer to. You've got 28th of October, you see that, 2013, that's 29.1. And then going through, there's one in June 2016. That's an undated letter. We don't know quite exactly where it comes from, but it's sometime in June 2016. 21 August 2017. And then 10th of September 2017. So you've got 5 general reservations of rights over the course of 6 years, with a 2.5-year gap between numbers 2 and 3. So we have described that as sporadic rather than a consistent reservation of rights. And if you look at my note, paragraph 189, you'll see what we say about long gaps in communications generally, where not only are there no reservations of rights, but there's nothing said at all. So between 27th of September 2012 and 30th of September 2013, nothing happens. That's a year. Between 4th November 2015 and 16 May 2016, nothing happens. That's in 6 months. And then you've got another year between June 2016 and June 2017. Now, we rely in particular on we rely on a number of different points of affirmation, but I'll identify three. The first is on the 23rd of October 2014 in a letter to Her Excellency Al-Hashmi, and you'll recall there was some discussion about whether that was intended to be communicated to the defendants and therefore whether it could amount to an affirmation. But if you look at the terms of that letter, it's clear that it's intended, and indeed if you look at the evidence that supports it from Mr. Al-Majid, it's clear that it's intended to be passed or communicated to the DIFC, and we say at 1596, is it, sorry, 1926, apologies, 1926, we say, or 1916, we say, that's the reference, and the words are, if we receive a positive reply, we will have no option but to commence work and injection of the required capital immediately. So that's the first one. Then there's the meeting with the governor, which we don't have direct evidence of, but we have the claimant's or Mr. Romaizan's letter from later, where he records what was said at that meeting in September 2015. And his words are that the parties agreed that the above contract is ongoing, binding and enforceable. So that's his account of a meeting that took place in September 2015. And then 8th of October 2015, you've got Mr. Ali's response set to Mr. Visser's approach, saying, I'm now instructed by Mr. Romazan that he and his partners have decided that they would like to implement the original agreement with DIFC Investments. So those three in particular, the most recent reservation of rights that's relied on is 28th of October 2013. The next one is June 2016. So the idea, we say, that the reservation of rights from a letter on the 28th of October 2013 could somehow affect, really, at all, a meeting with the governor, for example, 2 years later, or a response from lawyers 2 years after that, it is, we say, just unreal. There's clear affirmation on each of those occasions, and the reservation of rights cannot affect that. The next point, though, is that there is a express statutory test under DIFC law, and the test is set out in the contract law itself. And if you've got the authorities bundle, I don't know if it's worth going to, but it's on page 1025. I can read it out into the transcript if it's going to take too long to go there, because it's quite a short passage. I'm afraid I don't know where your bundles are split, my lords, so I can't really help you with that. Should be tab 33.
Just read it out, but it's the provision of contract law, is it?
It's a provision of the contract law. It says notice of termination under the heading notice of termination, Article 87(1). The right of a party to terminate the contract is exercised by notice to the other party. And 2, if performance has been offered late or otherwise does not conform to the contract, the aggrieved party will lose its right to terminate the contract unless it gives notice to the other party within a reasonable time after it has or ought to have become aware of the non-conforming performance. There was a suggestion in opening that the time begins to run from a different date than breach. That's wrong. It runs from breach. And if there was any doubt about the words of the contract law, as you know, the contract law is based predominantly on the unidroit principles. And so we've got the commentary from unidroit on those principles. And the reference in the bundle is to page 1092, and that makes clear it runs from breach. So even if there was some prior fundamental breach, you'd have to determine when that occurred. but the time to terminate has, we say, long gone. Whatever the meaning of reasonable time, it's got to be less than 6 years. You have, I think, my submissions on limitation. The short point on limitation is that 6 years runs from the date of breach. Again, that's written into the contract law at Article 123. So it is not sufficient for my learned friend to identify a pre-limitation breach, which was accepted post-limitation. It's the date of breach that matters, not the date of acceptance.
What is your position on the claimant's stance that everything post 2012 is effectively without prejudice in the context of seeking to settle a dispute that had arisen as a result of the letters of renunciation?
So what I say is that that means that they cannot establish a breach of a duty to negotiate at all during that period, because they are not trying to negotiate a shareholders agreement consistent with the joint venture agreement. They're trying to negotiate something else. It takes two to reach an agreement, and if one party accepts that it's not participating in that behaviour, then there can be no breach during that period. And then the second part of it goes to where I'll come to this on quantum, which is the could and should. Could and would have performed the contract. And I say it goes to that as well. They never intended to go back to the joint venture agreement. And that is why ultimately when we said, and the DIFC said, let's go back to the joint venture agreement, that is the time when they terminated, rather than in the 6 years in the run up to that. So it goes to those two points.
Most of the correspondence doesn't have any heading of without prejudice on it, does it? There's the odd letter, I think, that does, but it's by and large there. It's all, on the face of it, open correspondence. Doesn't mean they're not trying to settle, but
yes, I think that's right. That's absolutely right. Does that mean they're not trying to settle? I don't think it necessarily does. We hadn't understood that to be their case. I think we had always said we did not think that they wanted to pursue the JVA. Whether one characterises that as negotiations or not is a secondary question for us. That the critical question is, are they trying to pursue the JVA? If they're not, there's no breach and no loss. And I think that's why it was something of a remarkable change and about face in the opening when they said, no, we were just trying to settle. Because that's effectively, we think, an admission of the points that we've been making all along, that they did not intend to pursue the original agreement.
Yeah, my question relates to any issues of affirmation.
Oh, I see. Yeah. Well, I think one has to look at the critical issue, the particular communications, as to whether those particular communications appear to be intended to settle a dispute or are. And so I see what you're saying, but if the answer is that actually outwardly, and this is why we say it's important to bear in mind that they're doing one thing outwardly and another thing inwardly, and so there is a plan to present one face when something else is going on behind the scenes. So even if internally, for them, this was all about settlement, if they sit down with the governor and say, we agree that this is a binding agreement, that may be step one in now let's talk about what happens next. But that is not the settlement of a dispute or an attempt to settle a dispute. That's just, we agree that that's binding, let's move forward. So one has to look at the individual communications, I suppose. And identify whether you think that those were genuinely attempts to say, without prejudice to all our disputes, we're going to do something else, and nothing changes as a result of this communication, or whether actually, as we say, they are just letters saying, no, we've considered what our position is, we want the contract to remain in place, and now let's negotiate a solution. So in a sense, what I'm saying is that even if there is this settlement negotiation line, those communications are not part of that.
Well,
the precursor to that.
At first blush, on an objective reading of the correspondence, where there is no heading of without prejudice, I wouldn't have seen any of the correspondence, I think, as being capable of qualifying for without prejudice communications to settle a dispute. I mean, it looks like more efforts to agree terms of a joint venture deal in the same way as they have before.
Yes.
But I'm quite keen to understand what both parties' position is on that.
Yeah, I think. Yeah, no, it's. I think our position is that we anticipated that there could be a dispute,
Yes.
and clearly there are. I think communications from both sides where they say what we say here is without prejudice. And I think it's difficult to apply a sort of broad brush across the whole of the set of communications, because some of them are directed at saying, you know, we are not admitting that there is anything has been done wrong here. But there's no attempt to sort of settle a sum for prior breaches. I think from our perspective, those three communications I've mentioned to you would not obviously be part of any settlement discussions, and that's what matters from our perspective, I suppose. I mean, ultimately, though, there's been a lot of focus on affirmation, but that is not the statutory test. The statutory test is reasonable time.
Well, I understand that point, but on the face of it, where some documents are specifically headed without prejudice and others aren't, the ordinary inference would be that the others aren't.
Yes.
You know,
yes.
If you have a whole sequence of correspondence and someone forgets in
That's
one
fair.
letter to put without prejudice on it, you may very well be able to say, well, it's quite plain the whole of the correspondence is intended to be without prejudice. But if you get some letters which say it and a whole bunch that don't, am I entitled to make that sort of inference?
I think that's fair.
I don't know.
Yes, I think so. I think that must be fair. In the same way as reservation of rights, you know, there are some reservations of rights and then lots of communications where that does not happen. One might say, if they happen very shortly in a short procession, as you say, some people leave those sorts of markers off their letters, and it's not determinative. But if then you have long periods of communications where it's not being used, then yes, I suppose one would say they're not without prejudice, even if they are in one party's mind intended to settle something or intended to resolve the position between the parties in circumstances where they feel that if the resolution doesn't arise, they have a claim. I think that's probably what the claimant means by intended to settle, settlement discussions.
Yes.
I'm not sure I can help you much more on that, so, but all right. Where was I? Yes, so affirmation and reasonable time. Limitation I've dealt with. There's then, of course, the question of renunciation, anticipatory non-performance, as it's called in DIFC law in 2018. And I don't propose to deal with this in great length. The question is whether, as at the date of termination, it was clear that there would be non-performance of the JVA by the defendants. That's the test from the legislation. And you have obviously seen the performance letter, as we've called it. That was also sent by email, and the email in terms said to Hexagon, we want to go back to the joint venture agreement. We say there's no reason to doubt the bona fides of that letter. And the reasons that have been given to doubt the bona fides don't stand up, because all of those complaints about the viability of the project were really about the project computations. And when one gets to the performance letter, really what that's about is financing. And so there's nothing in that letter which rules out the parties coming to some agreement about the JVA. And what it just says effectively is, let's get on and get back to the JVA on financing. Please inject the capital and let's get on with it. And the other point there, of course, is that you can see what's going on behind the scenes at the DIFC. So you have the board minutes, which show that Mr. Visser was instructed to proceed with the project and to negotiate a resolution if possible, but nevertheless to proceed with the project. So if there was, again, some sort of overarching plan to present one face and do something different, then that would have emerged from the documents that you have been shown. So for all of those reasons, we say there just isn't a claim here, and none of it can succeed on liability. I don't know whether you have any further questions on the liability side of things, but I was going to move on and look at the quantum. The quantum, we start at page 40 of our note with some principles. We start with the basic threshold that one has to satisfy in DIFC law, which is that you have to establish with a reasonable degree of certainty that there will be a loss or has been a loss. To that, we should perhaps add Article 9 of the Law of Damages. Again, if it's very short, but I can just read it out if needs be. It's at page 1050 of the bundle. Article 9 says, what it does is it enshrines the compensatory principle into DIFC law. So it says the aggrieved party is entitled to full compensation for loss sustained as a result of the non-performance. Such loss includes both any loss which it suffered and any gain of which it was deprived, taking into account any gain to the aggrieved party resulting from its avoidance of cost or loss. So there's no restitutionary damages in DIFC law for contract breaches, even if that's available in English law, which we say it clearly isn't. But anyway, but the fact that the compensatory principle is codified into English law may be important for the next question, which is whether or not, well, who bears the burden of establishing the could and the would? And so we say that there's no doubt that it is essential that the claimant could and would have performed the contract. That's the JVA. That is an essential component. But from his note, I take it that Mr. Williams disagrees with my suggestion that it is for the claimant to prove that. And so there appears to be a dispute between us on the burden of proof. I take that from his note, not from his submissions. I rely on the glory wealth, which we've referred to in our opening, and it's a decision of Mr. Justice Tier. My learned friend relies on, I think, an article or a snippet of an article. It doesn't actually appear in the quantum submissions, it appears in the liability submissions. And my learned friend's closing note, which he produced yesterday. And there's a snippet of an article from Edwin Peel in there. Can you remind me where it is? Sorry, I've just lost it actually. Gateway to damages. So it's on page 11 of my learned friend's note. So we don't have the whole article, and I'm afraid I haven't had time to dig it out. But as I see it, he criticises the decision of Mr. Justice Tier that it is for the claimant to prove that it could and would have performed the relevant contract if it's looking for loss of bargain damages. I mean, I'm not proposing to engage directly with this. I think the point here is A, when he was going through the authorities, Mr. Justice Tier was emphasising the effect of the compensatory principle. That was at the centre of his reasoning in the glory wealth, and that was why he said you can only succeed on a loss of bargain damages if you would have fulfilled that bargain. It's your claim, it's for you to prove. So fundamentally, though, ultimately this is a question of burden of proof. And in relation to that, on the would part of it, you've got Mr. El Fadl's admission. Not foreseeable. on the could part of it, we've got your order, my lord, which I will now show you, if I may. I'm afraid we're going to go into bundle B for this. Tab 2. A rarely used bundle. So this is, we refer to this at paragraph 224 of our note, but we're looking at bundle B, tab 2. I have to rotate it. This is your lordship's order on document production against the claimant, and it's order number 1. All internal documents in the period 2012 to 2018 relating to the claimant's ability and or willingness to invest the total project capital by way of liquid finance pursuant to Schedule D of the JVA, to include without limitation. And then you've got a series of specific items: evidence of cash balances, other assets, agreements to borrow funds, correspondence, proposals, documents evidencing any discussions with third parties about the provision of funding, minutes of board meetings, emails, WhatsApp correspondence. This was disputed and resisted, but you will just see from the final column, court's decision granted. And so what we have is the question: could the claimant have produced, depending on the model, $200 to $400 million of cash to fund this project in liquid finance? And by this point, it seems to me we're rather beyond questions of burden of proof, because how else would the defendants prove that the claimant simply doesn't have this, other than putting them to proof and asking them to produce these sorts of documents? And in these sorts of documents, in relation to this, we've got admissions by the claimant's witnesses that these sorts of documents exist. We set out those admissions, some of them, in our note, paragraph 224. And of course, they must exist, because if you've got cash balances, you will have bank statements. If you've got shareholdings, you will have shareholding certificates, or you will have registry entries. So in those circumstances, where there are documents which exist, which you've ordered be produced, but which have not been produced, you are entitled to draw adverse inferences, and that is RDC 28.61. What we have is a single check. It's in bundle F1, tab 2, page 10. It's in Arabic, but we hear that it is made out to a different party altogether. And from there, all we have is pure assertion by Mr. El-Majid and pure assertion by Mr. Hossan as to Mr. Romazan's capacity. So that in relation to the check, that's supposed to be in relation to a deal that was done in 2012. We're told that it's payable to a party who is owned by Tamniat, which is said to be owned by Mr. Al-Majid. The cash is said to have been transferred. It's said to be available. And I made the submission, well, everyone would laugh if I claimed to have $200 or $400 million. But if I went off to a bank and said, I've got a client who's a billionaire, please lend them a very large sum of money, here's a check to prove it, the bank would ask for a little bit more. And the question, I suppose, for this court is, why should it accept less? My learned friend also suggested in his closings that the evidence on the claimant's ability to proceed with the project was, he used the words, effectively unchallenged. I mean, with respect, that is not an accurate submission. There was plenty of cross-examination on this, but of the relevant witnesses. So we say, but on both the question of could and on the question of would, you have the material you need to make a decision, and your Honour should find against the claimant on both issues. And again, that is terminal for the claim. As to the date of assessment, there is law. Is it 2013? Is it 2018? And a friend said there wasn't, and it's effectively a discretion. That is not accurate. We set it out at paragraph 209 and onwards. Your Honour knows the basic principles. Of course, we've moved quite a long way away from date of breach as being the date for assessment. Of course, the logic for date of breach is that where you have a market, you can go into the market. And so if you don't have a market, if you don't go into the market, then that's not a loss that flows from the breach. And that's why sales of goods cases are the sort of paradigm date of breach cases. But that's always been subject to exceptions, even in those sorts of cases where there's a claim for loss of bargain and there's a gap in time between breach and termination. And so we set that out. There's a passage in Chitty which we refer to, but we set out the underlying authorities and the relevant passages at 211 and 212 and 213, which is actually a New South Wales Court of Appeal decision. But it's very clear from all of these, first, the anticipatory breach. Where there's an anticipatory breach of contract, the breach is the repudiation once it has been accepted, and the other party is entitled by recovery by way of damages the true value of the contractual rights which he has thereby lost, subject to his duty to mitigate. The fundamental breach, in cases where a breach of contract for sale has occurred and the innocent party reasonably continues to try to have the contract completed, it would, to me, appear more logical and rather just than tie him to the date of the original breach to assess damages as at the date when, otherwise by his default, the contract is lost. And then it's made even more clear in the New South Wales Court of Appeal case. I'll just read you the final sentence. The critical date is when the bargain was lost. So it's not the final sentence, but it's 3 lines up from the bottom. So it is the date of loss of bargain. We say that's the logical date anyway. And in fact, as Your Honour observed, if you allow for 6 months of negotiations from the date of termination, or the date of purported termination, you get to something in the middle of 2019, which is a year later than is assumed in the quantum models. We're not saying that that affects the inputs terribly, but what it does do is it saves another year of discounting. So what it does mean is that the discounting applied by Mr. Brandt is 1 year more conservative, if I can put it like that. What are the assumptions for you in making that assessment? We talked about fair wind yesterday, and yes, there is a fair wind, but A, that does not reverse the burden of proof, and B, it does not eliminate the need to discount for loss of a chance. When you make that assessment, this is paragraph 214, Your Lordship assumes that the defendant performs its minimum obligations, and that where there are a range of possible ways to perform, it's assumed they will perform in the least onerous way to them. There is the no cutting off the nose point, but that doesn't take one away from the terms of the contract, of course. So on this, we say, well, it's quite difficult to understand how the claimant could move, or the defendants could be obliged to move away from the master plan, even if you accept that there's some flexibility in the project computations, even if you can get away from those computations that were in the original joint venture agreement. At best, the best case has to be, it seems to me, the approved, what's so-called approved project, not the HBU project. Paragraph 215, we provide authority for the proposition that you need to apply hindsight when making the assessment. And we also provide authority, which shouldn't be controversial, that you discount for accelerated receipt. And then also we say you have to model the risk. And that is what discounting achieves, and I'll come on to that. But there's quite a helpful passage in Mr. Kramer's book, which we refer to and give the reference to. And effectively what he's saying is, if you know that there's going to be a profit, if you'd like to see it, we can go to it. It's bundle M. It's probably whichever is the last volume of that. and you'll see if we go to tab 43, page 1099, quite a helpful discussion about where the claimant might even have made a loss. If you see that at 1856, I might just let your lordship read those two paragraphs, 56 and 57. So where the effect of pursuing the project could have ended up in a loss, if one thinks about all the different outcomes that there might have been and assigns a probability to them all, then one has to take into account the probabilities of making a loss. One doesn't just say, here's a possible profit and discount that by a number, by a percentage. One has to do a more complex computation. And obviously, the complexity of that computation depends on the circumstances, and the courts are well attuned to doing rough and ready computations of that sort. But here, that is the process that in part discounting achieves, because it incorporates the risks of the various different outcomes that there could be. My learned friend yesterday said, well, you can't incorporate risk into the discount rate. That's not an appropriate element of the risk of the discount rate. We say that's wrong, both because you have expert evidence on it, but also because it is consistent with actually what you're trying to do here. Dealing then with the experts themselves, we make some comments on the testimony of the experts, paragraph 231. I won't go through them in detail. We give some fairly comprehensive notes on that, and your lordship will have formed a view of Mr. Williamson in any event. We would describe him as thoroughly unsatisfactory, I'm afraid. He was evasive, he was defensive, he was scripted, he repeated particular mantras, and on many occasions just did not want to engage in the discussion of the logic underpinning his opinions. And he repeated over and over again, this is not a science. Of course it's not a science, but that is not an excuse for refusing to answer questions about the reasoning underpinning your outcomes. And he quite often reconstructed his reasoning, and it tried to explain away problems with other problems. And one example, which is particularly glaring, is he simply refused to accept that he was using hindsight, even when he said he had been doing so consistently, and then was using data for his 2013 model, which came from 2017. And his answer was, it's just I'm using trends, as if that was some explanation, which obviously it wasn't. In terms of the actual difference between the two experts, quite a lot of it, according to Mr. Williamson, could be explained by the use of hindsight. And I'll come back to that in a moment. But actually, on a lot of issues, there wasn't a great deal between them, save that all of the trends were down, and they were down for two reasons. One is obviously the pandemic, and that was a temporary adjustment. But both experts accepted, and Mr. Brown gives evidence about it, Mr. Williams accepted it in his cross-examination, that between 2018 and the pandemic, there was a significant dip in the fortunes of these sorts of projects in any event, so rates and so forth. In terms of Mr. Brown's evidence, the claimant's case on this is, I would suggest, rather hobbled by its approach to cross-examination. It's easier to tell you what my learned friend did cross-examine Mr. Brown on than what he didn't, because it was a very short list of things. He was confronted about a number of issues, and we will deal with them. But on two absolutely critical issues, there was no cross-examination at all: discounting and the rate of office rent. He had quite a lot of submissions on the rate of office rents, but no cross-examination on it. On discounting, Mr. Williams tried to suggest that there was some cross-examination. I don't know where he gets that from, because there just wasn't. On the principle, there was nothing. And certainly on the rates, and the methods of applying discounting, there was nothing. So, for example, Mr. Williams criticised Mr. Brand about failing to introduce interest on past income flows. He suggested somehow there were deficiencies in the models. Mr. Brand had answers to those questions. You didn't hear them because he wasn't asked about them. He was just simply not cross-examined on it. So I would suggest that it is just not open to Mr. Williams to challenge his evidence on discounting. Now, of course, you're not bound by what a witness says, by what an expert says. But unless it's completely out of bounds, in principle, there's no reason not to follow the evidence, as you put it, in submission. In terms of discounting, there's one quite telling observation I would make about the appropriateness of that. You want to ask the question, how is it that the highest and best use analysis produces more profit than the approved project? How could that be right? Doesn't that indicate something's wrong with the model? And I can show you what the difference is if we look at a table from Mr. Brand's report. If your honour has bundle E, it's my volume 2, it'll be tab 7. Page 365. It's 365, my lord. So what you've got here is a summary of, in the table 125, of Mr. Williamson's undiscounted calculations for each project, 4 of them, and Mr. Williamson's discounted. So if you take all the inputs and apply some discounting, and what you see is in scenario 1 and 2, which is both 2013, you see the approved for Mr. Williamson is higher than the profit from the HBU. That's the oddity that Your Honour picked up on. And it's the same in the 2018, of course. So you've got 755 versus 569 million. Now, why is the approved higher than the HBU, the highest and best use? Well, we can see that if we go across to the discounting, so if you discount those outcomes, that result switches. So you can see, starting with the 2013, just discounting at, say, a 10% rate, you get a loss of 153 million on the approved, but a profit of 279 million on the HBU. So it's gone from the approved being more profitable to the HBU being more profitable. What has changed? The application of discounting. So the reality is, you're right, a model which produces a higher profitability for something that's supposed to be highest and best use has gone wrong. And from this we can see how it's gone wrong. It's gone wrong because it doesn't account for discounting. Sorry, you're on mute.
That's not the explanation for 2018, however, is it?
Yes, it is, because if you see those in minus numbers, so the approved is very, very minus, and the HBU is only a little bit minus.
Yes.
That's really.
Yes, right. Okay.
Yeah. So it works, and obviously what this illustrates as well is that once one starts applying discounting, even with a very modest discount rate of 10%, you are looking at a loss-making project. So,
I'm not sure that I follow the logic of that, though. Why it should make that difference?
Why? Because in the HBU, a lot of the point is that the money is released as you go, and so there is less, that the money comes less in the future. So as we see it, so on the 2018 model, even taking into account that extra year, if we started in 2018, you're not getting your money until 2029. Whereas on the HBU approach, you're getting it periodically as you go. So once you start taking into account the value and the difference in value and the cost paid now and in the past, as against
it is the cash flow point that I was putting to Mr. Williams, to all intents and purposes. Cash
flow is part of it. I'm not suggesting that you would have, if it was just cash flow, a 10% discount. No,
but it affects the discount, obviously.
Yeah, absolutely. And I'll show you a little bit about the IRRs, the internal rate of return, for some of these models on the different inputs, because those inform you about what is the discount rate you would have to apply at its minimum before you could break even. That's effectively what the IRR is, the internal rate of return. Yeah. So we'll come on to that, but just dealing with the reasons that were given for not discounting. What are the reasons? Everyone accepts it's completely exceptional not to discount. So why are we not discounting in this case? And the answer comes back, commitment, because the Hexagon is committed to the project. But that's nonsense. All that's saying is that they could and would have proceeded with the project. And so that is a precondition of any claim to damages. It's not an exceptional reason not to discount. It's a feature of every single successful damages claim for loss of bargain. In his first report, Mr. Williamson also relied on the fact that the joint venture company could not borrow. If you recall that, he said it 4 times in relation to each project. And that didn't make any sense either. It might reduce the element of discounting attributable to cost of finance for the JV co, but it wouldn't affect the position of Hexagon. And so Mr. Williamson abandoned the point and said, actually, well, I only put it in there to support my conclusion based on commitment, which I think says more about Mr. Williamson's evidence than actually anything about the conclusion. Now, my learned friend, Mr. Williams, tried to sort of rescue that particular part of the point in his submissions, and he suggested that commitment meant there was no cost of financing element to the discounting and that it should be taken out, in effect, from the discount rate. That is wrong in any event, because whether or not Hexagon was borrowing or whether or not it was using its own money is irrelevant, because the question is, what has it lost from not being able to do this project? And so if the conclusion is it would get just as much money from putting its cash into bonds as putting it into this project, then it hasn't lost anything from being deprived of this project. And so the opportunity cost of borrowing is just as relevant as the actual cost of borrowing. It might be less, but it's still there. And actually, if one looks at the materials underlying how one goes about discounting, it refers to the cost of borrowing and the opportunity cost, I think, of equity being factored into discounting rates in any event. But none of this was put to Mr. Brand. None of it wasn't suggested to him that 20% was too much, or that it ought to take into, or it would come down if you took into account interest, or if you took away some element of cost of funding. Taken in the round, what Mr. Brand said was that 20% was a reasonable discount rate, but he gave a range, and it's worth just looking at how this all comes out. If we look at page 294 in the same bundle. Table 12. So unless your honour is attracted to the 2013 HBU project, what you see is even a 10% discount rate eliminates all of the profits. And this is using Mr. Williamson's inputs. And if you look at, this is the point about IRR, if you look at the internal rate of return for the 2018 projects, you get a 5% return on the approved project over the course of 12 years with a 1.5 billion dirham or thereabouts upfront investment. For the HBU project is about 8.7%. Now you'll recall when we were dealing with capitalisation, the difference between the experts was 7 and 8% on rates. It's a slightly different concept, that, but it's effectively doing the same job for part of it, 7 or 8% on capitalisation for the future value of an income stream. So it's hard to see how you're going to get any kind of profitable project, even on Mr. Williamson's figures and his inputs. But from here, I'm afraid, things get even harder for my learned friend, because of the limited nature of the cross-examination. Before I get there, though, just to deal with the site, one of the things my learned friend said in his closing submissions is that, and he put it like this: everyone agrees that this is a prime location in the DIFC. That, I'm afraid, is simply not accurate. Mr. Brand's view was that this is prime Dubai, but not prime DIFC. And he makes that clear. He did accept it was the best remaining undeveloped plot in the DIFC, but obviously most of the DIFC has been developed. But he did make an express distinction between central prime DIFC and this project. And it's page 306 of his report, same document, paragraph 129. Second sentence, in my view, the selected buildings have premium location. He's talking about the gate, precinct and Al Fatan Currency House. The selected buildings have premium location within DIFC, which is DIFC's northern campus considered as prime DIFC, whereas the property's location is less attractive because it's on the other side of Al Mustaqbal Street. Now, as to Mr. Williamson's view, his view was that it wasn't prime for all purposes either. So his view was that it was prime for offices. He accepted that when it came to retail, when it came to residential, it was not prime. It was comparable to the Burj Daman. That in itself, we say, puts pressure on his Berkeley Square analogy. And just to try and give you a bit of a better view, I'm afraid that the photographs aren't hugely helpful. You asked me at the outset, can we show you some better photographs? I mean, I personally would have no problem with your lordship looking things up online, but I suppose that's not ideal. But in any event, if we go to page 285, start there. You can see a plot from the master plan from 2016. So Al Mustaqbal Street is this big road that runs down the middle. It's a 3-lane highway on either side, and then you've got the plot at is the top right red, or the rightmost red plot there, and then you've got I think Sky Gardens, and then across you've got Burj Daman on the same side of Al Mustaqbal. It might be easier if we go actually, the plan that Mr. Williamson referred to was in his report. I'm probably going to come back to Mr. Brand's report, but if we take up Mr. Williamson's report, I think it is even clearer, frankly. If we go to page 10. So he's got this plan. What he's done is he's drawn his Berkeley Square includes Al Fatan Currency House, the precinct, the gate village, which is broadly a square if one cuts out the Ritz-Carlton, but that's different, that's a hotel. And then what he's done is he's added on a bit across the road and said, well, that's Berkeley Square. And the first point I think is it's not very square. And it's not all part of the same place. It's across the road. So I think what Mr. Brand is saying is if you look at the Sky Gardens is the next one down on this side of the road, and then you've got Burj Daman, which is a mixed-use hotel, offices and residential development, and that is the best comparator because it's on the other side of the road, which is a 3-lane highway. There are no bridges, and although it looked like one was planned, it's not obvious that there is going to be a bridge for this particular development. And what one sees from this plan is that if you're going to include PA01 with all the alpha tan currency house, you are artificially cutting out the corner, which is Bauge de Man. And so what Mr. Williamson did was he basically said, well, I'm taking rates and so on from the gate precinct and alpha tan currency house, and I'm just going to discount them by 10%. And we suggest that that's just an arbitrary approach to it. The better approach is the one that Mr. Brand took, which is to look at the actual rates which were achieved by comparable properties like the Bauge, in particular Bauge de Man, and that is a much better guide to the sort of thing, rates that you're going to achieve. That's on the plot. One of the things that was challenged, one of the primary inputs, was obviously this question of efficiency. And I start this at page 48, we're getting there, paragraph 257. And you know, I think, that what had happened is that Mr. Brand gives a global efficiency estimate across the board of 70% for the whole thing. Mr. Williamson says, no, it'll be 75% for offices and 60% for retail. Now, Mr. Brand was cross-examined on this, and he was accused of not being objective. You've breached your duty to the court, Mr. Brand, for failing to take into account a particular document. It was never suggested to him that he'd actually seen the document before. It was a historic document. It's in the F bundle, page 826. Quite a lot of weight is put on this one. Oh, it's not 826.
It's 836.
836. Thank you, my lord. I'm sorry, I should be ahead of you on this sort of thing. And one of the points I just observe here is that if you look at the overall efficiency on this document, it is not 75%, it's not 85%, it's 72.95%. So again, the cross-examination proceeded broadly on the wrong basis. But the main point about this is that this is a internal document produced, it's aspirational, it may or may not be achieved. What Mr. Brand has done is he's looked at the efficiencies which can actually be achieved, particularly bearing in mind the height of the property. And I'll come back to that in a moment. The other thing that he was cross-examined about was the feasibility study that was prepared by JLL at page 1623. We don't need to go to it. It had an 80% figure in it, but Mr. Brand made clear that figure was provided to JLL. That was an input that was provided. It wasn't an estimate by JLL of what could be achieved on that project. Everybody accepts, when one actually comes to the evidence rather than these historic documents, everyone accepts that height affects these things. So as you get a taller building, efficiency goes down. And Mr. Brand looked at the range which was achievable, which was 60 to 75%, and he took an efficiency range, a rate from above the middle of that range. Mr. Williamson took one which he accepted was, in his words, absolutely the top end. Absolutely the top end. Those were his words. We recite that at paragraph 259. And his evidence appeared to be that, in effect, this would be value engineered at the design phase. And one only has to look at the experience of Perkins and Will to see that there are limits to that. And one of the things that he refused to accept was that there would be any particular design constraints on this building. He accepted that if there was a design element, in other words, that there was some sort of outcome, aesthetic outcome that needed to be achieved, that would impact on efficiency. Everybody accepts that this was intended to be something that was, quotes, iconic. My learned friend accepted that in his closing submissions yesterday. That's day 10, page 53, and page 116. It's also clear from contemporaneous documents from March 2012, and I'll give you the reference, which is F1785. So if you're going to be imposing that sort of requirement on the design, everybody accepts that the efficiency comes down. Mr. Brand had not taken that into account, neither had Mr. Williamson. So what I say is that 70%, frankly, is likely to be a generous outcome in relation to that. The next major input, and if we go down to the revenue that was going to be achieved, we look at paragraph 263 from onwards, there are, in relation to each of these items, broadly 3 categories of factor which go into the revenue for each type of thing, particularly with rental. So you get the rate of rental, the occupancy that will be achieved, and the take-up rate. Take-up rate being how much space can be leased each year, or on a net basis. Rate is, on the approved project, the office rental rate is absolutely the critical point, because of course you've got a 97% office space here on this project, and it all gets capitalized. That revenue gets capitalized at the end to produce the payout in 2029 for 2018 project. On the rate, Mr. Brand was not cross-examined at all. So the difference in the rates we record at paragraph 269, little 1, I'm afraid it's a bit of a jumble, but in 2013 it is 230 dirham against 190. In 2017 it is 216 versus 170. So the reason why I say 2013 and 2017 is because of the use of hindsight. In effect, the real differences between the two experts were A, hindsight, and B, the appropriateness of comparing the development to Burj Daman. And so you see, for the 2013 project, the way it works is that Mr. Williamson's evidence was that you get a rate of about 230 per square foot. But then he was looking at the rates that were achieved in 2013. He wasn't looking at the rates that would be achieved when they came out in 2017. And we know when this project was coming online in 2017 from the evidence that prime DIFC was achieving around 240 per square foot, and for big units much less, 200 per square foot. So we say it's simply not realistic, once one applies hindsight, that this project would be coming out at around that sort of level, because then it really would be having to compete with gate precincts. It wouldn't actually incorporate the 10% discount that even Mr. Williamson accepted would be required. So if on Mr. Williamson's own numbers, if one applies hindsight, it all comes down anyway, quite significantly. And the reason for Mr. Brand's evidence was that Burj Daman was getting something like 170 to 200 dirhams per square foot. And that's according to Mr. Williamson's own evidence. We see that at E84. There's a table there. But again, none of this is cross-examined on, so I'm just telling you this because it's indicative that you can't just throw out Mr. Brand's evidence as being completely out of kilter. This is all reasoned. If one goes to E84, there's a table there for Burj Daman. This is from Mr. Williamson. In the middle, do you see Burj Daman coming online 2014? You go down 3 boxes, you get achieved rates and occupancy in 2018, 170 to 200 per square foot. So the average for that is something like 185. Mr. Brand said 190 for this plot, PA01, was about the right number in 2018. So that's for the 2013 project. That's why you've got that difference between 230 and 190 on the 2013 project. What happened next, everyone also agrees. The market then fell. And Mr. Brand said it fell by 10 to 15%. That was not challenged. I cross-examined Mr. Williamson on this. He did not disagree with it. And that is why 190 goes down to 170, which actually is a 10.5% drop. So that, again, the suggestion yesterday from Mr. Williams that Mr. Brand was consistently taking the extreme end of the scale is absolutely wrong. One sees every time he takes a generous approach. So one gets from 190 down to 170, and that is why there is a difference. A, the relevance of Bauge de Man. B, the effects of the pre-pandemic decline. The only thing that Mr. Brand was challenged on in his evidence on this front was office take-up. And that was how much space can be leased each year. You will recall some fairly trenchant criticism of Mr. Brand. Mr. Williamson was far less clear in his evidence, and I would suggest really by this point he was very much in retreat on what he was saying, and he accepted that this is a difficult area, either party could be right. We say his evidence was just totally over the top on this. He was saying 150,000 square feet per year was going to be leased over the course of 6 years consistently. That is double anything that the objective evidence observed anywhere else. And Mr. Brand said even that objective evidence would have incorporated a degree of cannibalization, that is so it's not net increase. So you've got to find net demand in the DIFC, or you've got to eat other people's tenants. We say on that Mr. Brand is to be preferred, but this issue is not anything like as important as the issue of the actual rental rates for the properties. That's office revenue and the inputs. On retail, there were also some differences, and I've tried to summarise them at paragraph 276. Again, Mr. Brand was not cross-examined on any of it, none of it. So I won't linger. He's explained his reasoning. It was perfectly reasonable. I cross-examined Mr. Williamson. It's right, it's difficult to say that Mr. Williamson's views in specific cases were excessive. For example, on occupancy, there's only a difference of 7.5% between them. It's difficult for your lordship to say, here's an objective criteria which shows that one is right and the other is wrong. But part of one of the side effects of the absolute lack of cross-examination of Mr. Brand is that it's difficult to say that he really did anything or said anything which would give you reason to doubt his views. As to Mr. Williamson, I would say the opposite is true. Yield was quite important. Your lordship recalls the capitalisation rate, 7 and 8% was there was a difference there. Again, Mr. Brand was not challenged. He explained his rate by reference to examples. So he gave a range of examples, and you'll recall that the lowest of those was 6.5%, I think, and there was another at 6.75%. But there was one at 10% in the DIFC. And Mr. Brand took a point which was well below the middle of the range. He said, look, this is the range that one might get. Higher is obviously leads to a lower profit and therefore lower damages, but he took one not at the higher end, not even halfway, but below halfway. Mr. Williamson wrongly criticised him on that, but took it back eventually when I had to show him what he'd said about it. Mr. Williamson's evidence was, we say, unsatisfactory on this in any event. So effectively where we got to was on his written evidence. He said, knowing the things we know about the project, the variables that are really important are location. We know the specification, but that's going to be the same wherever you build it. What really makes a difference when one looks at these comparables is location. But then he hadn't spotted that the Index Towers was available as a comparable. So then he had to retreat from that. And eventually where he got to was to say, you know, none of these comparables are really matter very much. I think it's Berkeley Square. Trust me, I'm a professional. This is my opinion. So we say that actually his evidence on that was completely unsatisfactory anyway. But again, Mr. Brandt's was perfectly reasonable and not challenged. So at this point, I was just going to pause because that completes in effect the approved project and say, what do those inputs do to quantum? And just show you what that does. If we go to page 207 of Mr. Williamson's report, so just dealing with the 2 points that are important and were not challenged: office rental rates and yield. Office rental rates is dealt with in figure 25. This is Mr. Williamson's sensitivity analysis. You'll see Mr. Williamson selects his 216 per square foot in the centre, and then he provides a sensitivity analysis of which Mr. Brand is off the scale. So he would be at 170. So another 15 or so reduced. I haven't done the calculation, but if you go down, you can see that just taking it down to 184 reduces the profit available that he's calculated on a pure profit and loss before discounting, before all the other factors I'm going to come on to, down to 411 million dirhams on a pure profit basis. So if one takes it down to 170, you are looking at something in the region of 300,000 dirham, 300 million dirham as a profit. I would suggest that reducing the rates to something reasonable knocks about half off the entire profitability of this project. In relation to yield, we can see that on the next page, page 208. And we do have the numbers here because we've got the difference between 7 and 8. And we see that it knocks about a third off the profit. So just on the basis of the unchallenged differences between the experts, there's going to be a composite of those two, which will reduce it way below the 300 million, because you've got to add in then the effect of the yield analysis on that, and you're starting to look at something which is, really not an attractive, very low profit, if I can put it like that. We don't have the full sensitivity calculations for all of this, but I'm just trying to give you a sense of how these things affect everything, and that's without factoring in efficiency. So if you're with Mr. Brand on efficiency, it would go lower still, and that's before we get to any level of discounting. Just dealing as quickly as possible with the HBU project, highest and best use project, and just the inputs that are different on that. Probably the best place to do this is if we look at paragraph 286 of my note. Let me just pick it up there if we may. Again, in relation to this, on the highest and best use projects, Mr. Brandt's evidence was basically not challenged, save in one respect, but it was misguided on the ADR for hotels. I'll come on to that in a moment. You'll see, firstly, in relation to office space, there's a much smaller amount of office space in the mixed-use project. So it's less significant, but it's indicative of Mr. Williamson's approach. He allowed for 100% occupancy for that through the life of the project. Mr. Brand gave some discount. There's not a huge difference in quantum, but again, Mr. Brand wasn't challenged. In relation to residential units, which will probably, I would suggest, make up quite a lot of the larger, I think it's 66% of the project was residential, so it'll make up most of the revenue, but make a very significant difference to the cash flow, obviously, because a lot of it's being released off plan. You'll see the differences diminished, but were significant. So in the 2013 project, it's a difference between 1900 and a profile of 1750 falling to 1500 per square foot. If you see that at paragraph 288, and then we've got a difference of 1600 falling to 1500 per square foot. Again, Mr. Brand was not challenged on any of that. That's for residential. There was a difference between the parties on absorption, which is how quickly those would be sold. The difference was paragraph 291 of the note between 11.5 and 10. we explain how Mr. Brand gets to that point, perfectly reasonable. It's not a great difference, but again, it's difficult to see how you could reject Mr. Brand's evidence, given he wasn't cross-examined. You then get to hotel. Oh, there's a point about timing of recycling of money, which only really matters for discounting, I suppose, and also the maximum amount of finance that's required. This is the point that until the project is 20% complete, everything has to stay in escrow. And so in order to model it, you have to work out when that will happen. And you'll recall that Mr. Williamson accepted that it would be 6 months before to start construction. And then you've got to get to 20% completion in 6 months, which is just unrealistic. So he accepted that might not have been achieved, which is something of an understatement, we would suggest. So again, Mr. Brandt was to be preferred. And then there was a difference on sales fees. If you recall, there was a question about who in the market normally adopted or absorbed those sales fees. Mr. Brandt said it was normally the developer. And of course, that's all going to be factored into price. If the developer is not absorbing the sales fees, then the marketability of the property diminishes. So that's quite significant. And again, Mr. Brandt wasn't challenged. Then we get to hotels, and this is where he was challenged. So the hotel ADR, you'll recall, was quite different in 2013. The evidence had it being, Mr. Williamson suggested 1,000 dirham per unit, and Mr. Brandt said 711, going up to 819, to take into account it coming online in 2017, dipping with the pandemic and coming back. The key headlines for this was that in 2013, it was all accounted for by hindsight. So all of these points about the STR set are irrelevant because they came out at exactly the same place. You may recall I took Mr. Williamson to the graph, and we agreed that the graph actually fell pre-pandemic to about 820, which is where Mr. Brand got to post-pandemic after the recovery. So it was all about hindsight, and he actually agreed that with hindsight, it was perfectly reasonable. That's paragraph 298. We had the same, there was a difference in the occupancy profile, given this dip with the pandemic, and so that was an effect of hindsight. And then we had the same sort of issues in relation to the service apartments, which you see at 302. It's all about hindsight. When it comes to the 2018 rates, actually they were pretty much the same, and in fact Mr. Brandt had them higher, which you see at paragraph 297B, 2971B on page 52. So Mr. Brandt was saying, look, it gets back to about 852. Once one takes into account COVID, there's a moment for COVID, but then it recovers to 852, whereas Mr. Williamson was saying 832. So again, it gives the lie to the submission that somehow Mr. Brand is just over-egging everything. He's not. And then there's this, of course, there's the same issue with exit yield in relation to all of that, because you have to capitalize it again. So there's the same issue of 7 or 8, which wasn't challenged. Costs. I've set out the differences at paragraph 314. Apologies for the slightly crude nature of the table, which was hastily added after the submissions. But you can see the difference between the approved projects, the costs for that are not significant. The real issue is the difference between the costs for the HBU projects, which are quite significant. And the point here is that it was always accepted that the experts would need to rely on input from others in relation to costs. They're not quantity surveyors. They're not experts in construction costs. They are able to sense check costs that they're provided for. What you have from Mr. Brandt is detailed costings, or more detailed costings. So it's not a tender, it's not a proper tender specification, but it is more detailed than a price per square foot. You have that at page 386 of the bundle. E386 is a high-level costing report. And if you want to take the time to look at it, you will see an attempt is made to break it all down a little bit. My lord, I've probably got about another 10 minutes or so to go. So are you happy for me to carry on rather than take a break now? Very happy to do it either way. You're on mute, my lord.
For transcribers' benefit, we probably better take a quick break now.
Thank you.
Thank you.
Dealing with costs very briefly, I was making the point that if we look at, you'll see them eventually, I don't need to take you to them in too much detail, but the differences between an internal costing by JLL on one hand and Mr. Williamson's resort to prices per square metre on the other. Mr. Williamson did accept that the JLL team was competent to prepare those costings. So there's no issue about the credentials. The complaint is about the independence. But what I say is that as long as it is someone who is independent from the party, there shouldn't be an issue about it. It was never one of those situations where your lordship was anticipating and given permission for a series of experts across a range of disciplines all to provide a certain amount of expertise on this sort of thing. The only difference, the only material difference, is that the JLL approach is more detailed. We say that there are demonstrable problems, though, with Mr. Williamson's approach, and we set that out at paragraph 308 and onwards. And the first is quite remarkable, and you would have seen his face fall in evidence, but he hadn't provided enough parking floors because the size of his parking floors were larger than the size of the site. So even if you could use every square metre of the site, he still had to find 100,000 square feet of parking, or he needed to build another floor. He explained that away as just design, but of course it's not just design, because the deeper you go, the more expensive it gets, the less efficient it gets, the more problems you encounter. And so either his costings don't account for that sort of thing, in which case you can see why it's better to have something like the detailed approach from JLL, or alternatively he's just giving excuses. But either way, it doesn't reflect very well on him. He also failed to allow enough spaces, and I showed him the detail of that. You have a bit of the detail in paragraph 310, which is there's a municipal obligation that service departments are treated as apartments, whether they're hotel or not, and they require one parking space, but he'd only given them 0.2. And the other point was he'd failed to account for enough parking for the residential, and didn't really give any good explanation for that. Again, Mr. Brand's evidence was not challenged, so there you are. So that's the inputs, and we'll come back to where it all comes out to in a moment. The next issue is shareholding split, which we've discussed to some extent. I mean, that is obviously an issue of law, in the sense that it's for you to determine whether or not there was to be a reconciliation at the end. What Mr. Williamson does is he adopts a fixed percentage of 20%, and Mr. Brandt has taken the value of the land into account and compared it to the sums that are being invested. Where he comes out, you will find in Mr. Brandt's report at page 363. It's probably just worth familiarising your lordship with that. 363, my lord, in bundle E.
Yeah, the figures between 72 and 76%, aren't they?
Exactly. And the effect of it on the 2018 projects, you can see as the difference between the 750 that he says for, you need to compare two different figures. You can find the figures over the page for Mr. Williamson. So Mr. Williamson's loss of profit for the 2018 JVA approach, or the approved approach, is 756 million approximately, but the effect you see in the middle of Mr. Brandt's table 1, 2, 3 brings that down to 630 million. So you've knocked off about 125, 130 million, whatever that is, as a result of that adjustment. And then on the HBU approach, the adjustment down to 74% from 80% brings it down from 569 or 570 thereabouts by about 105 million to 465. So again, you've got downward pressure from that to pile on top of all of the problems that I've pointed out on Mr. Williamson's own figures without even getting to discounting of any sort. So, and the point here really is this point about inconsistency of the case, because unless Mr. Williams gives up his point about deletion of that adjustment mechanism, then there's no scope at all, it seems to me, for any kind of argument about computations changing, because the bit about computations changing is in this bit that Mr. Williams says has been deleted. So either the case fails, or at least you've got to, and on the premise that the case succeeds, it has to be in there. If you accept, and that's, as I say, if you accept Mr. Brand's inputs and take a pure profit and loss, that's where you get to 628 and 465 before discounting. Where does this get us to? There's quite a helpful table if we turn to 348, and again, I'm just trying to give your lordship a sense of how these figures come together, because we don't know where you come out on all of these issues, and there's going to be a compound effect of them all, and we've got some sensitivities but not lots. If we look at page 348, you see where we get to with Mr. Brand's inputs on a pure profit and loss before shareholding. So this is just cash flow. Table 98 is for the approved project in 2018. And you see that he says, and this is where there isn't a great deal of difference on cost. He gets that as a total development project of that. So that would be for the joint venture company of 423 million. So that's before shareholding. But the important bit there is that our internal rate of return is only 2.85%. So over the life of the project, you would be better off putting your 1.5 billion dirhams or 1.6 billion dirhams into a bond. That's the point. If we go forward to 350, you see the actual profit shares effect on this project. And if you take into account the 76% that on this model, if you have page 350 and table 101, you see that for Hexagon, the project becomes, with Mr. Brand's inputs, a cash loss over the 12 years of the project. So it's a 50 million dirham cash loss. And of course that gets much worse with discounting. For the HBU project, if you go forward to page 360, you see the cash flow on his inputs. And for the project, it is, so that's for the JV Co, you get 118 million cash profit with an IRR of 1.35%. So you don't have to look too far to get that kind of return from a bank. And then if you factor in the cash in the profit share over the page, we see from table 121, it is a very significant cash loss for Hexagon, 318 million. And that's all before discounting, where it all gets significantly worse. So
it's all on his figures.
Those are on his inputs, yes. So what I did was I showed you first of all.
Yeah.
Yeah. So if you accept my case on discounting, any 2018 project is gone. If you don't accept my case on discounting, but accept my case on the figures and the shareholding splits, the case is gone. There's no profit. And any combination of those factors is likely to lead you to a loss. I think what I'm trying to give you a sense of is the extent to which you have to be with both the legal and the factual case on experts in order to get to any kind of profit. So if you just go back to considering the threshold question, is there reasonable certainty that there's a profit here? No. 2 minutes on the alternative way the case is put. We don't accept there's a restitutionary basis for damages. I'm not going to address you on that. On the reliance cost basis, where do we get out on that? So this only arises if you conclude that you just can't say whether there would have been a loss or a profit. So those are the circumstances in which we can resort to reliance loss. If you accept my case that there wouldn't be a profit, there's no room for this, because it's all on the premise that, as a rule of thumb, costs usually generate profits. But that would involve rejecting, we say, unchallenged evidence from Mr. Brand. And actually, if we look at the evidence which has been produced on it, there isn't much. If you look at it, there's a table which is in bundle F3. No, sorry, F4. Bundle F, volume 4, tab 233. And there's a spreadsheet that's produced. It's spread over 2 pages, I'm afraid. So this is the centre of the case. It's not actually attached to any witness statement or evidenced in that regard, but nevertheless, this seems to be what is asserted. So first of all, you've got D1 and Perkins and Will design fees. In relation to those, you will note, we put it in our note, that the final entry of 1.291 million was not paid. And there's a reference to that at page F1848. But it's in my note. So actually, some of it wasn't in fact paid. And there are really 2 points to make about these sorts of costs. You'll see in relation to consultancy, you've got things like DG Jones, who are the quantity surveyors. There's something for Gensler. That's the concept design of $150,000, presumably. Various other items which aren't properly explained, frankly. Mr. Mukadem, who charged a fair sum for negotiations and so forth. Mr. Van Diver, who was the person who reviewed the original Perkins design and gave it a bad bill of health, and 1 or 2 others. And then you've got TPM, Project Management Services, being some sort of TAMIAT entity charging its alleged Hexagon. There are 2 points to make in relation to this. Firstly, you'll see that goes up to December 2009 for TPM, but everything else seems to be really about the design process and in particular Perkins and Will. We say all of that is clearly wasted in circumstances where the design couldn't work, and when at best they're saying let's go back to the different agreement in January 2010. So there's no loss there. And the second point is, when you look at any documents, you will see that TPM was working for Concept, not for Hexagon. Perkins and Will were engaged by Concept, not by Hexagon. And there's no proper explanation of why it would be that Hexagon had to pay that, or that it could be a loss for Hexagon. There's no real support for any of this in any event. There's no invoices, there are no receipts. There are no bank statements or anything of that nature. So we say, regardless, it just couldn't work. So that is it, my lord. I did want to just do one thing, which is to give you those references you asked for about the presentation. But before I do that, if there are any questions that you have about quantum, I'm very happy to answer them. If not, I will show you the route to the point that the particular slide that I mentioned was included in one internal presentation, but not in the subsequent presentation. So the reference is firstly to bundle D, page 109, which is a witness statement which exhibits it. This is it, by it I mean the February presentation that I showed you. So this is Dr. Adele's witness statement. D109 behind tab 5, paragraph 35, and you'll see the last sentence. The DIFC still had not provided feedback on CSI's scheme by February 2012, and you'll see a footnote 37. That footnote 37 takes you to the TANMIAC presentation on the status of the project dated 15 February 2012, slide 14. And that is the document that I took you to in bundle F, document 215, page 1760. There is no suggestion or evidence that that document was provided to the defendants, and you will recall in that document at page 1775 you have the slide that I took your lordship to, which is the one that said CSI, the funding structure did not materialise. That comes after the picture. It's 1775, my lord. The previous slide is the picture, CSI concept. And so then if you go forward in the bundle to tab 222, you see an email dated the 2nd of May from Mr. Abdul Sami to the DIFC, and it attaches the following documents. You see that, and one is the presentation explaining the background. Then if we go forward to 1815, we see the new presentation, which is dated now the 30th of April 2012. That's 1815. And then if you go to 1829 and 1830, you see those two slides that preceded the one I showed you at 1775, but then you go over to the next one and it's been removed.
Yeah, thank you.
My lord, unless you have any questions, those were my submissions.
No, thank you very much.
Thank you.
My lord, I don't know if you can see and hear me.
Yes, thank you.
I intend to be very brief, and I think Mr. Williams will be as well. And we'll certainly aim to get done by 3. My lord, I want to start with this question of agreements to agree on uncertainty. This, as I understand it, and I'm sure you will correct me if my misunderstanding is wrong, you have raised this issue of your own volition in the context of you need to adjudge the endeavours or lack thereof that were exercised by the DIFC that we say amount to breaches, and there is a clear factual question of what those endeavours were and whether they can be adjudged as not complying with the obligations, and that we accept, and we have addressed that, and I'm going to give you a couple of points on it. That to me, though, is a long way from an invitation to the DIFC to abandon their pleaded case on the enforceability of the JVA and now run a case the JVA is an unenforceable and void agreement. And in our particulars of claim, and I'll just give you these references to consider in due course, paragraph 11 and 12, we set out the obligations that we said were enforceable. Paragraph 13 of the defence, paragraph 12 is admitted to the extent that it suggests that the terms of the joint venture agreement are enforceable and binding on the parties from effect from 14 December 2003 and modified thereafter by the amendment. So all the submissions that you've heard today about it being an unenforceable agreement per se, I say simply aren't permitted and can't be pursued. And the only live issue on the authorities is whether the factual questions that you need to decide in relation to the exercise of best endeavours and good faith are things that you can adjudicate on, or whether it's not possible for you to adjudicate on because it's too uncertain. And on that, my lord, you've had a lot of cases from us, a lot of cases. I think it's a bad place to start with the commentary, but once all of the authorities have been laid out, it's the commentaries that help us the most. And on that score, I don't know whether you're accessing authorities on your case line. If not, I might just screen share the passage from a passage from Lewison that I think both parties have referred to. Would it be easier to screen share that?
Probably, yes.
Yeah. I'm just going to get Ms. Wong to put this up. So this is Lewison chapter 8. You've already been referred to his discussion on whether Legate J's decision should be preferred over Danny Lyons, and he adopts he says the Danny Lyons view is the better view. Just on Atlas, my lord, I accept, and it's obvious that best endeavours with respect to an arrangement with a third party is a different scenario, and in some ways it's easier, in some ways it's not. I don't rely on Atlas as a factual analogy. It's the principles that Legate, as was, addressed in that case. And the ones, if you look at page 7 of our note, it's really the passage where the criticism involves a matter of fine judgment. It may be impossible to establish breach. In other cases, however, the absence of reasonable endeavours may be obvious. It does not follow from the fact that may have been often difficulty in proof that there is no obligation at all, or the obligation has no sensible content. So that's the principle we rely on there. If in the Lewison, Ms. Wong, if you could take up paragraph 8.128 of that. And after a long discussion of all these principles at the conclusion, what the author does is summarize Lord Justice Ricks's decision in Mamador. And my lord, for the purposes of your deliberations, I would respectfully suggest you read these. And this is really the principles, and these are the ones that we're grappling with. And the first one is incredibly important, own facts on the construction of the own agreement. 4, in commercial dealings between parties who are familiar with the trade in question, and particularly where the parties have acted in the belief that they have a binding contract, the courts are willing to imply terms where that is possible to enable the contract to be carried out. And then 5 and 6 are fairly obvious. But 7 is particularly apt to this case. This is particularly the case where one party has either already had the advantage of some performance which reflects the party's agreement on a long-term relationship, or has had to make an investment premised on that agreement. So those, I say, are the actual principles that we ought to be considering here. And what are the facts? What are the objects that we need to be considering? And we put in another reference to Keating on construction contracts, and you may say, how's that going to help me? This is a commercial case. Well, these type of arrangements crop up a lot in construction contracts, and the significance there is what the author does. It refers to all of the cases that are here. And it says there's a difference between where you are just to use best endeavours to negotiate and where the best endeavours are attached to a result. So in other words, something you need to achieve. And that's the case in the territory that we're in here. because here it's the clause 3.1 breaches, and it's the position with the background, the very important background at 2010 through to 2012, and there, what we say is that the question for you is, looking at where the parties have got to, looking at where the agreements were up to, looking at the things that needed to be done, the mechanical exercises as they've all been described of the SPA and so on, what endeavours were exercised by the DIFC with respect to those? You can take this down now, thanks. What were they, and were they their best? And the very simple answer, and it is often the case that big disputes, commercial disputes like this, come down to something very simple in the end. There were no endeavours. They never exercised any endeavours with respect to those issues. Now, financing, we've never said that best endeavours applies to agreeing the financing terms. We've never alleged a breach of the financing obligation in Schedule D or anything like that. That is something that is thrown out because it suits them on the authorities. Now, as you observed, the position between the shareholders agreement on financing and the memos needs to be considered. What we say in the memos is we're still responsible for it all. We still bring it all in, and there's no change in that obligation. Now, my interpretation of what is put in that memo differs from Mr. Montague-Smith, but what counts is two things: the evidence, and the evidence from Mr. Al-Majid is very clear that the mortgaging requirement was something that came in as a benefit, but they didn't need it. And the second thing, my lord, is, and this is the really important bit, because for this exercise, you were looking, your adjudication of their compliance with the obligation is what did they do with respect to their endeavours, best endeavours and good faith, when they got those two memos. And it simply can't be said, as it has been in closing, bare assertions from counsel, well, it might have been the global financial crisis, or they might have changed their mind, or it might have been this. You have no evidence whatsoever that they exercised any endeavours at all. So this falls into one of the simpler categories, because they just didn't respond. And we can speculate as to why. The evidence you have from the claimants is pretty clear. They were told two things: A, they may have changed their mind, and B, the changeover in management meant this was in a freeze and would go slow. There may be valid explanations for as to what happened, but there's certainly not evidence of exercising best endeavours. And in response to that, and this is really the nub of the whole case on liability, it's page 112. What Mr. Montague-Smith said is, I agree the joint venture remains binding. The content of the duties doesn't require any more action. So his basic case is in 10, 11 and 12, we didn't need to do anything else. And the reason? The obligation had been exhausted. Why had it been exhausted? We had done it. We did it in 2008 with the shareholders agreement. We can't go on forever. Well, if that's their case, it really falls apart in its entirety, because what was required from that point on was a share purchase agreement, company coming in, land getting transferred. If there were changes to be made to the shareholders agreement in relation to Hexagon, and we were to revert to the old arrangements on financing, or just keep the 2008 shareholders agreement arrangements on financing, is neither here nor there, because the parties had done it and got there. So in that sense, these provisions, these obligations are clearly enforceable on the authorities. Your inquiry as to adjudication, as I said several times in this case, it's difficult in 2007 and 2009, but you need to look at that to get the background. And you have to be satisfied that come the eve of those subsequent 2 years, there had been sufficient progress, and there wasn't anything that they could point to as saying, we've exercised endeavours and it didn't get us there. It then becomes incredibly simple. My lord, the next point I want to address very briefly is this reasonable time under Article 87.2 of the DIFC law. And I say there is, again, a very simple, obvious answer to this. What is a reasonable time depends on the circumstances. And here, the parties thought that the elapse between 2013 and 2018 was reasonable because they kept talking. and they signed off on standstill agreements, and they kept negotiating. At no stage during that period did the DIFC say, this has been going on too long. The period of time to decide what to do with your reserved right is over. You need to make up your mind, get off the pot or sell, but you can't keep vacillating. They never said that. So on the evidence, you have a clear position between the parties that that was a reasonable period of time. And then let's think about this logically. The idea of the law is to help commercial parties get their job done. Why are we as lawyers in a better position to judge what is reasonable than two commercial parties who thought it was worthwhile to keep discussing the prospect of coming to another arrangement? And the only thing I'll close on this score is you asked the question about what are those communications. Now, without prejudice communications, as you've alluded to, can be tagged WP, or they might not be, but then they can still relate to negotiations. The settlement negotiations in my submission reach various points. We're going to try and do a new arrangement. We might buy the property. We might sell it to somebody else. There were various things that were being discussed. Were those discussions about avoiding a litigation? And if the answer to that is yes, then whether they are formal without prejudice communications or not is neither here nor there. They are certainly communications geared towards trying to avoid where we've ended up, which is in court. My Lord, the only other things I wanted to address was just some tidy up. Sheikh Al-Mana and the document that you were shown at 1868, there was some theorizing from counsel about maybe Sheikh Al-Mana was going to come in and maybe he was taking an interest. And that I'm afraid is rank speculation. It's very clear what was going on. You just have to look at the authority document on the next page that was proposed to sign off. He was coming in as an intermediary to carry out settlement negotiations on a without prejudice basis with the DIFC because we weren't getting anywhere. And that's the proof is in the authority and also from the claim that's just been made. He charged for his time to carry out the negotiations. So in the sense that that's raised as any sort of unusual or untoward activity, I say you can dismiss that. Second, on tidy up, my Lord, you were shown, and it was the page you were shown was F177, I think. This is the presentation of the 15th of February, 15th of February 2012. Now, this is the document that confirms, if I got that right, yes, it's 15th February 2012. And the document is, it starts at F1760 and goes to F1778. Now, this, my Lord, was the document I think that was relied upon with respect to CSI coming out. And we say that is not, my Lord, an internal document. There was a presentation to the DIFC on the 15th of February 2012. Now, can I prove a chain of custody? Can I show you an email of it being sent to the DIFC and forming part of the presentation? No, I can't. But if you look at paragraph 34 of Mr. Sami Al-Fadl's statement, he refers to that taking place. And I say the inference you ought to draw is that that was the presentation given at that meeting. And that would mean that all of the contents of that, including the position in relation to CSI, was brought to everybody's attention at the time. I don't actually think anything swings on it. And the reason for that is, yes, CSI didn't advance, but the design concept that they presented was one tower, which was consistent with what we were talking about. And because the DIFC didn't engage with us, we weren't able to advance things with them. So at the end of the day, I don't think it takes you anywhere. Lastly, my Lord, is this. You have throughout this trial asked questions of both sides in relation to F333 and the following page with respect to the shareholdings. You used the word shrouded in mystery. Mr. Montague Smith used the phrase mist of time. the reality is this: if there is anything to be drawn from that mystery of sinister proportions or time proportions, the inference ought to be against the DIFC. And the reason for that is pretty simple. Your Order 8 in the document production required them to produce all internal communications to and from the governor of the DIFC between May 2004 and November 2018. You cut it down to 12. Relating to Hexagon, the shareholders and ultimate beneficial owners, the JV company, the JV as amended in the project, that's B127 of your order. The minutes, as you will, if you want the page number, it's 12156. The page number of that, in that document, in that board meeting, there was a reference to the audit in relation to Hexagon, which suggested there'd been some fraud and misrepresentations. That has not been produced to you. We say it was very clearly part of the order and should have been produced. In the I bundle, I know judges at the best of times don't enjoy solicitors' correspondence, but if you look at I-114 in your deliberations all the way through to I-1334, sorry, 134, so it's I-114 to I-134, you will see the explanation. We are the Radapay situation and all of this fraud was relevant, and we were told politely buzz off. So I only raised that in case it is something that you need to consider in any more detail. And then lastly, it relates to Mr. Al-Najjar. You look at the rubber hit the road period, 10, 11, and 12. The reason we put his 2009 communications and then a 2014 communication was to show that he was involved that whole time. The fact that he didn't engage with this is just a creature of what the DIFC did. So it's simply wrong to say he wasn't involved during that period. He is the only man from the DIFC, or the only witness who can tell you about that period. It can't be Mr. Barazzi because he was out the door. And it can't be Ms. Calaresi because she didn't come until 2011, and by her own admission, she only dealt with the legal side. So we do say that as a witness, he is key. And if there are absent explanations like what endeavours they exercised, it's only him that can address them. So, my Lord, I'm going to hand over to Mr. Williams and give him the floor for the final moments of this case, unless there's anything I can assist you with on the points that I've raised.
Thank you very much.
My Lord, and I'll do my best to close things up on quantum by 3. Just firstly on discounting, the defendant's speaking note at paragraph 247 says that Mr. Brand wasn't cross-examined on discounting at all. Mr. Montague-Smith repeated this in his submissions, no cross on the principle of discounting. My Lord, that's incorrect. Mr. Brand conceded during his cross-examination that he'd not looked at or considered the parties' 16-year relationship, nor applied his mind to whether that rendered appropriate in the circumstances of this case, a valuation with everything that entails, i.e. discounting, or a straight loss of profits, which would not entail discounting. The references, my Lord, are in the claimant's closing note at pages 14 to 16, and the key passage really is on page 15 of the closing note, where during Mr. Brown's cross-examination he was asked by counsel, now I'm going to be very fair with you and make this very plain. A genuine, independent, impartial expert would say to his instructing solicitors, before I express views on things like efficiency and whether this should be a valuation or a loss of profits, I need to know where the parties got in their negotiations. That's correct, isn't it? And Mr. Brown's response was, I requested all the relevant information with regards to design, JVA and the documentation, and I've relied upon what I've been provided with. So in our submission, Mr. Brand completely conceded that he'd not formed an independent view, but rather he'd followed instructions and he'd relied only upon what his instructing solicitors had provided. Had Mr. Brand turned his mind to the particular circumstances, he would, or he should, have concluded that this case does not involve a willing buyer, willing seller making an investment decision. It'll be a matter for you, my lord, but our submission is that Hexagon was committed, indeed it was contractually obligated to proceed. A DCF simply not applicable. It doesn't quantify Hexagon's loss, it quantifies the value for a hypothetical seller or buyer.
And are you saying that point was put to the witness?
Certainly we're saying the point was put as to whether in principle this should have been a valuation or a straight loss of profits. And when the term valuation is used in the context of Mr. Brand's cross-examination, it would have been readily apparent that we're referring to a RICS valuation, which is what he conducted or purported to conduct in his report, where discounting would naturally flow from that definition. My lord, the short point is the RICS Red Book, which you're taken to in Mr. Williamson's re-examination, expressly sets out what the rules are in terms of when you're valuing an asset or a right with respect to a committed party as opposed to a market participant. And that is, it's the value of the asset to that particular owner or prospective owner for the individual investment or operational objectives, and that's in section 6 of the RICS Red Book 2020. The definition implies, and in contrast to market value, this basis of valuation doesn't envisage a hypothetical transaction. It's a measure of the value of the benefits of ownership to the current owner or the prospective owner, recognising that these may differ from the typical market participant. So, my lord, we absolutely submit that Mr. Brand was cross-examined on this fundamental point of principle as to whether he should have been conducting a valuation or a straight loss of profits in accordance with the RICS Red Book, which I'm sure he's extremely familiar with.
Would you like to take me to the relevant passage in the cross-examination?
Yes, my lord, it's the passage I read out to you and it's on page 15 of the claimant's closing note. It starts at the relevant passage starts at the bottom of page 15 in the transcript reference. So the transcript reference is day 9, page 40. Seems to have gone something wrong with the reference there, but it must be around pages 43 and 45 of the transcript on day 9. But in any event, you've got the passage quoted in full here in the closing note, and at the bottom of page 15, he's asked specifically about whether he had the information available to him to make the decision himself, as opposed to it being merely an instruction as to whether a valuation or loss of profits should have been conducted. And his response, my lord, we say is a concession that all he relied upon was information as regards design, the JVA, and the documentation. And in the context of the evidence Mr. Williamson gave as to his consideration of the entire contractual history of the parties, and him exercising his professional opinion and judgment that what was appropriate in the circumstances of this case was a straight loss of profit, we say is not an exercise that Mr. Brand could have conducted, because had he done so, he would and should have concluded the same as Mr. Williamson on this point.
On you go, Mr. Williams.
Moving on to the other point that's said about discounting, that Mr. Brand wasn't challenged on the computation of the discount. We say that Mr. Williamson raised the point about credit needing to be given with respect to interest in his second report, and that's at paragraph 2.7 of his second report. He also made the point during his cross-examination. We've put the extracts from the transcript on pages 17 and 18 of our closing note, And in an effort to assist the court, he offered illustrative examples of the impact interest would have, but the DIFC, as you're aware, my lord, objected to the admissibility of that. So we say it can't be said that the claimant has not challenged the way Mr. Brand has applied his.
He wasn't asked about it.
Well, we say he did not need to be cross-examined on it. Of
course he did, Mr. Williams. You know the rules. If you're going to challenge an expert on a particular topic, you put it to him so he can give an answer. That wasn't done. The cross-examination of Mr. Brand was absolutely extraordinary, and I know you weren't here, and you had domestic issues and so on, and Mr. Sprainge had to undertake it. But even allowing for that, great chunks of his evidence simply were not challenged, and that's essentially the beginning of end of it. Unless I think he was talking absolute nonsense.
Well, my lord, I hear what you say, and I won't press on this point.
This is what happens in arbitration with great frequency, and it's a disgrace. But it's unacceptable in court for this approach to be taken. I'm not saying it was taken deliberately. I don't know why it was taken, but that's the approach that was taken.
My lord,
the points that Mr. Montague-Smith makes in his closing about the matters that were left unchallenged, that is the reality of the position, and I'm stuck with it.
My lord, as I understood, the purpose of Mr. Brown's cross-examination was about overall credibility and reliability. And so, my lord, you're aware, for example, the points Mr. Brand made on hotels and ADR, we've still not got to the bottom of, and the fact that Mr. Montague-Smith says that that's immaterial to the outcome, that particular point, is not, from our perspective, reassuring. And in terms of the other points that Mr. Montague-Smith sought to place reliance on, the fact that Mr. Brand had not been challenged, we say he didn't need to be cross-examined on it, to the extent that, well, firstly, if his credibility and reliability has been put beyond doubt as being unsatisfactory, which of course is a matter for you, my lord, then we say that none of it, the contents of his reports, can be relied on. So that was the purpose of the cross-examination from our perspective. But looking at it in a less controversial way, as with any input in an expert report, the competing numbers are there. For example, rent, ADR, they're explained by both experts and reasons are given. The numbers are obviously challenged in the process of the two reports and the joint report, and our submission is the court is then free to prefer one or the other expert's views, whether there's cross-examination on specific detail of it or not.
That's not how it works, Mr. Williams. I'm sure you know that. I mean, words fail me. In an English context, I'll say no more, but
my lord, I'll say no more other than the context of that cross-examination was all about the reliability and credibility of that witness, and we say that none of his report should stand. And so whether he was cross-examined on individual parts of it, in our submission, shouldn't impact the assessment of that evidence, and it should be preferred.
I have to tell you, Mr. Williams, I took the view that there was no proper foundation for that line of cross-examination at all.
Grateful, my lord.
And in the context of English counsel, I would have been thinking, is this counsel in breach of his professional duty in putting that point? Not your fault, Mr. Williams, but that's how I see it.
My lord, focusing on Mr. Williamson's evidence very quickly, and we touched on this in the claimant's closing, the aspects of efficiency, rent, and construction costs. The suggestion that there needs to be a further reduction of these based on differences between the experts on those inputs. My lord, I don't need to go to Mr. Brand's evidence on it, because our submission is that on Mr. Williamson's evidence alone, reductions have already been made. So Mr. Williamson on efficiency adopted an efficiency of 75%, as you know, despite the party's well-documented objective of 80%, and the fact that there are buildings in the market with even higher efficiencies. And Mr. Williamson looked at actual efficiencies achieved in completed projects. he said in his testimony on day 8, and it's pages 71 and 72 of the transcript, that he'd taken into consideration actual projects developed with higher efficiencies than 80%, and therefore he was taking an incredibly conservative approach to efficiency. And the reason we stress that is because it's highly significant to the outcomes of the models. For example, in the 2013 approved project, Mr. Williamson referred in his second report in paragraph 3.2 to the fact that it had 195 million dirham reduction, the fact that Mr. Brand had taken 70% and not 75%. Well, the same operates in effect, dropping from 80 to 75. That's the reduction that Mr. Williamson has already given just by his natural conservatism on that input. In terms of rental income, Mr. Williamson, he's not applied a growth rate for rents on offices or retail. And that would be the assumption that's commonly applied, that rents on average will rise over time. But Mr. Williamson, he's taken a conservative approach by not applying a growth rate. If you factor in that in the life cycle of the project, you'll have typically you'll have market highs and lows with an average increasing, but Mr. Williamson maintains that rent for the entire 11-year life cycle of the project, and so that's a conservative assumption that has an effect on keeping profits down. In terms of the location of the property, that obviously has an impact on rental, and particularly office rental in the approved scenarios. So when Mr. Williamson looked at the Gate and Alpha Town Towers with rentals for office space per square foot of 250 dirham in 2013 and 240 dirham in 2018, he adopted 230 dirham per square foot in 2013 and 216 dirham per square foot in 2018 as a reduction for the fact that the plot PA01 is obviously across the street from that core prime area. But the point is that the plot is directly opposite, whether there's a bridge or there's no bridge, it's directly opposite the village precinct and the Gate, and developments such as Burj Daman simply don't have that same proximity. So, my lord, you have Mr. Williamson's sensitivities on rental income at the end of his second report. I took you to those yesterday. We say there's no reason to adjust the sensitivity, and certainly not below the scale that Mr. Williamson has given in those tables, as was suggested by the DIFC in its closing just now. On construction costs, just to finish up the last major input, those costs Mr. Williamson's adopted, as you know, from RLB, and he takes them from the mid to upper range of RLB, which means he's not trying to deflate construction costs in order to drive up profits. He's taking a very conservative approach on that as well, and we won't go to it because it'll take too much time, but in his second report at tab 2 of bundle E, page 203, there's a table, figure 18, deals with the HPU project in 2013, and you see a comparison of the construction costs adopted per square foot by Mr. Williamson and by Mr. Brand in comparison to the RLB range, and what you'll see in that, if you turn to it in your deliberations, will be that for the office and retail, which in the HPU project are obviously minimal, they're only 1% and 2% of the total development, Mr. Brand adopts very low construction costs as compared to the RLB scale. But when you look at residential, service departments, hotels, he's flipped and he's adopting extremely high costs when you compare that to the RLB scale for those use classes. And what we say is that is a clear demonstration of how costs are being selectively chosen in order to pick the highest cost possible to have the greatest impact on driving down profits. Just to answer a request you made yesterday as to references for where you'll find the total figures for construction costs and revenues, for Mr. Williamson, and they're all in his first report, so that's tab 1 of the e-bundle. For the approved project in 2013, you'll find that on page 31. For the HBU project 2013, you'll find that at page 59. For the approved project 2018, it's at 63. And for the HBU project at 2018, it's at 68. And so you'll have tables there of Mr. Williamson's computations where you've got total revenue and total costs, and therefore you can see the simple calculation of total profits. Just in terms of making adjustments on rough and ready basis, obviously one could increase costs and decrease revenues by certain proportions in order to tinker with profits. I guess one health warning on that approach is that, for example, increasing construction costs on the hotel would most typically mean a higher specification of hotel, which would then lead to it being more premium and commanding higher rates and therefore higher revenue. So it's not necessarily a straight trade-off between saying the costs that Mr. Williamson had used should be higher and the revenues because of rental rates or ADR and the like should have been lower, and therefore calibrating like that, there can be a disconnect, and the hotel's a fine example of where that can happen. In terms of another request, just the fair wind principle, we found a case which was one of your lordship's judgments, Gull Bottlers and Nichols. It's not in the authorities bundle, but it's another judgment that adopts the Yang Seng approach to giving the claimant fair wind in terms of adoption of assumptions in a damages calculation. Just to finish up also on other aspects of law, restitution is dealt with in the DIFC law of remedies. It's at articles 48 and 49. 48 says restitution is available where a remedy is expressly provided in the DIFC contract law or where there's been an unjust enrichment. And then article 49 deals with restitution, damages in lieu of restitution, and the DIFC contract law deals with restitution expressly at article 19. So, my lord, we don't accept the defendant's submission that restitution is an available remedy for breach of contract in DIFC law, and I've already addressed you, my lord, on the English law position with regard to restitution for wrong being an alternative way of looking at remedy with respect to a breach of contract. Just finishing up on the sunk costs, I addressed this in opening, so I just wish to flag that we gave various citations to the contemporaneous record of backup documents to the figures for sunk costs you see in this spreadsheet that my learned friend took you to, and leaving aside the documentary evidence backing up those costs, I think it's readily apparent from the record that all of the work detailed on that spreadsheet, the consultants, the designs, that clearly was work that was undertaken and completed. And so, one could almost adopt a quantum merit approach to that work and those costs, in addition to the documentary evidence that's in the bundle, and I cited in opening to support them. So, my lord, if there are no questions, those are our reply submissions on quantum, and I'll turn back to Mr. Strange.
My lord, nothing else from the claimant side on anything on liability. I've obviously heard what your lordship had to say about the cross-examination of Mr. Brand, but don't intend to say anything further unless you wish me to address it.
So up to you whether you wish to say anything, Mr. Strange.
No, my lord, I've heard what you've said. You've heard Mr. Williams' submissions. I think it's probably best if it's left to rest there.
Yes, all right. In which case, unless anybody else has anything to say, I shall reserve judgment, and you'll hear from me in due course.
Thank you.
Thank you very much, my lord. Thank you, everyone, for the week.
Right. Thank you very much, and thank you for finishing promptly tonight.